My lord, yesterday upon notice I mentioned the matter for extension of interim order which is expiring today. My lord, file is lying here, my lord. The matter is not appearing. Let it appear tomorrow, my lord.
The extension of interim order.
Similar interim order expiring today. And I gave a notice yesterday mentioning that I would mention the matter yesterday. Yesterday I got deal my lord. That's why I mentioned today. I will just give another.
My lord, this is contempt application.
A fresh contempt?
No, my lord.
Yes.
Fresh contempt.
Sorry, my
My lord, may I be permitted to mention? May I be permitted? Mentioning upon notice, my lord, for inclusion in the list.
Have you seen the first page of my list? What is stated there?
I did not.
Have you seen the first? Please see and come back. Okay.
May I permit to mention for one?
Only extensions.
Sorry, my
No
lord.
other mentionings.
My lord, contempt matter, my lord.
My lord, this is the extension of interim order.
Upon
Interim
notice.
order is expiring today. I have served notice, my lord. Grateful.
Very urgent matter because of is to issue the section 10 subsection 3 of the Highway Act and
Have you seen the first page, sir? You have to wait for your turn. Yes, call the days list,
My lord, may
please.
I have your lordship. I need to mention an unlisted matter for unlisted hearing, your lordship. An eviction notice has been issued under the Highways Act, your lordship, and which is it's due to expire tomorrow, your lordship.
The notice is for vacating. It is not a notice of eviction. been asked to
Removal of
vacate by
encroachment.
court.
Removal of
Wait for your
encroachment.
turn.
With my lord's kind leave, my lord,
Extension of interim order. Extension of interim order.
My lord, yesterday, my lord, I have filed my application. My lord, I am giving the number to my lord's court officer, my lord, that or some priority because, my lord, because
not just one in that.
Contempt application.
Madam.
Give the
Your
number.
lordship.
madam,
with my lord's
One
kind leave.
indulgence, my lord,
Chiara to Mone
I'm
Raghunath.
a restoration application.
Give the number.
My lord, there is a
Upon
sheer,
notice.
Yes, my lord. Upon notice.
my lord,
Notice is with the.
my lord, there is a sheer urgency, my lord. There was an order of interim order of stay, my lord. There was a proceedings initiated under section 10 of West Bengal Highways Act, my lord. Unfortunately, I could not appear before my lord, when the matter was called and matter got dismissed for default, my lord. There is a sheer urgency. Otherwise, they will proceed with the
Restoration.
restoration application. They will, yes, my lord.
Your lordship, may I be permitted to
Notice
mention
the-
item
yes,
number
yes.
711 of today's list, your
Yes.
lordship? It was earlier mentioned, your lordship, it is running under the mentioned matter, your lordship, but day by day it is going back to.
Can't help. If there are 200
Your lordship, it is very urgent, your lordship. I am suffering huge loss in my business, your lordship.
One matter which is not urgent, I'll consider your case.
Lordship, I'm appearing on behalf of the petitioner, your lordship.
Yes, item number 1.
Your lordship, I'm appearing on behalf of the petitioner.
Have
Your
you
lordship,
informed
by
the other side? Mr. Mahathir is appeared.
My lord. My lord, this is ready matter, my lord, long time.
yes, your lordship. Your lordship is pleased to pass lordship first interim order on 17 November 2022, and the same has been.
I'll fix a date. It's at the motion stage. I'll let
My
me fix the
lord.
date. Let there be an
My lord.
limited extension.
My lord.
Heard learned counsels for the parties. Paragraph. Let the matter appear under the heading motion on group 1 motion. 18th March.
18 March. I'm grateful.
My lord,
The interim order granted earlier.
my lord, some
extended
preference
till-
may be. Some preference may be given so that the matter can be hard out, my lord.
Come back. Let me see.
My lord.
31st March or until further orders, whichever is earlier.
I'm
2024.
grateful to your lordship.
এটা বলছেন, read করছেন। Next.
May it please the lordship. I'm appearing for the petitioner in the matter. My lord, I'm praying for an extension of the interim order. It is expiring today.
Hearing matter.
It's a hearing
Hearing
matter. It was
matter,
partly
yes.
heard by your lordship. And my lord, may I only pray for an indulgence, my lord. This is a matter which your lordship was pleased to hear partly and was pleased to fix it on 10th of January 2024. But it's down in the list. It is not being, lordship, it is there in the list, but it is, my lord, fairly down. So it's not being taken up. May I only pray, my lord, if it can be, my lord, I'll be very grateful, my lord.
Heard learned counsels for the parties. Paragraph. Let the matter appear under the heading group 1 hearing on 13th March.
13th March. I'll be very, very grateful.
After 14th, my lord.
14th.
After 14th.
So 20th.
Okay.
20th March.
Deep your
paragraph. The interim order granted earlier is extended till 30th April 2024 or until further orders, whichever is earlier.
Lord, would it be your lordship's pleasure to fix a time, my lord? Because I'm being led by Mr. Mukherjee, Shoktinath Mukherjee. He is not keeping too well, so we can indicate the specific time he will be ready virtually to appear, my lord.
Mark 3:30 will.
Any time it suits your lordships, my lord. 3:30, my lord.
3:30 mark hole first matter.
20th March.
20.
I'll just find out if there is any other matter fixed.
Lordship.
If I have 3 matters at 3:30, it will not help.
My lord.
Nahi to-
Earlier it was one or two occasion appeared as mark.
20th, 3:30. 20th, 3:30.
3:30. My lord, may I also pray, my lord, if the interim order is extended till disposal, then we will not trouble your lordship.
That I oppose.
That not-
It's going on.
Lord, my learned friend is,
since
lordship will come back.
2021.
In fact, my learned friend is opposing, my lord, for our benefit. I understand that. I'm very deeply obliged. to that.
Please come.
Madam, see, I am for the petitioner, I am for the whole municipal decision, madam, my lord. Well, earlier your lordship was grant the, well, I am for the petitioner, my lord.
Yes.
I am appealing for the whole municipality, my lord. Your lordship already. আমাকে শেষ করতে দাও, তারপর well, your lordship will please extend the interim order where renovation one toilet come restroom of the vendors.
Not at all.
And that land belongs to development department, government of West Bengal. How the private is claiming my land, my lord?
I'm not claiming.
And
I'm not.
in front of
Deliberately suppressing.
yeah, my lord. 17 feet
My land.
wide road is there. He's engaging in free, my lord. How my lord land free prejudice? I don't know, my lord.
Submission
Your
is
lordship,
my land.
I am the my lord.
Absolutely
of the
false.
public interest.
Hearing matter.
My lord.
ready for hearing, my lord.
Everything is complete, my lord. Everything is complete, my lord.
There will be a limited extension. Please come back. I'll fix a date for
My
hearing.
lord, first interim order was passed on 6/9/2022, my lord.
My lord, on behalf of the state, my lord, the affidavit in opposition has already been
Everything is
filed and
complete.
reply is all there, my lord.
No, affidavits are exchanged.
Everything is complete, my lord. A very limited time, my lord. The private respondent is suffering, my lord, till 2022.
I don't know, my lord. Wide road is there.
Group 1
You are-
hearing
Nothing, no.
on
Just encroaching.
20th March.
My lord.
20th March.
Interim order.
The interim order granted earlier is extended till 30th April 2024 or until further orders.
My lord,
whichever is
kindly fix a time, my lord. Otherwise, the matter is
all matters from these 3:30 you're aware.
2022, my lord, the matter is extended. On repeated occasion, I am suffering. My lord. My entire fund is encroached by the municipality.
In all
Illegal. Yes, encroached. Yes, encroached.
Next matter.
Well, I beg to appear on behalf of petitioner, my lord.
I am for the state, my lord. This is also, my lord. Everything is ready, my
I
lord.
am for the response number 2, lordship, suffering and interim order. I am beseeching your lordship.
My lord,
Kindly
I
take up the
mentioned
matter and
yes.
My lord,
My lord, I am also, my lord, ready to.
Yes.
My lord, I mentioned the matter, your lordship.
Very
It is
short
running.
point is
very
involved.
short
একটু বলে দিন। It is running at it's
The
running
term of
within
the
the 5
minded
matters.
has already been expired.
বলতো স্যার বলবো একটু এবার
না বলতে দেবো না বলতে দেবো
within 5 matters of the kindly fix a date, my lord, and time, my lord. I am also, I mean,
5 matters.
within 5 matters or remain in the same position, my lord. It will be taken up at any point.
Reply has been filed.
Yes, my lord, in the respect of MMTDCL, my lord, after long backs he filed the opposition. I will not file any reply because the same point was taken by the state.
The matter is ready for hearing. Paragraph, let the matter appear under the heading Group 1 hearing on lot of holidays in March. 18th March.
My lord.
Kindly fix a time, my lord. My lord,
3:30.
Hearing
All matters 3:30.
no, my lord,
Hearing starts from 3:30.
no,
Time they will
my lord, then my lord, matter remains in the same.
granted earlier is extended till 30th April 2024 or until further orders, whichever is up. If you
Yes.
ask for a time in all the matters, is it possible?
No, my lord, it's item number 5. It's retained in the same position. Then also matter will be hard, my lord. I am praying for extension of the interim order. There I have challenged the award which has been declared under the West Bengal Land Development and Planning Act 1952. Now, the subject matter of the challenge is this, my lord, that Supreme Court had struck down the provision of 8B and declaring ultra virus. Now, award has
Yes, we have filed our opposition.
yes.
It is running in the hearing list, my lord. Let it fix a date
Yes,
for
I
hearing.
think it's ready for hearing.
Yes,
My lord.
Let it appear in the
Yes,
hearing.
yes.
Yes.
The matter is ready for hearing. Paragraph, let the matter appear under the heading Group 1 hearing on 27th March. Paragraph, the interim order granted earlier is extended till 30th April 2024 or until further orders, comma, whichever is earlier.
Obliged to you. The next matter is the same.
But in this
Same.
matter,
Next matter.
item number 6, the opposition and reply is ready. Your lordship can extending the interim order, your lordship can keep it for hearing any suitable date. It's a
27th March, same date,
27th
same order.
March.
6, same order.
Deeply obliged to you.
Seven lordship.
My lord. I'm being late.
Yes.
My lord, I am appealing for the petitioner. The interim.
I am for the petitioner. Mineral development is the petitioner before your lordship and led by. Other side কই?
স্যার আজকে শুধু এক্সটেনশন অফ ইন্টারিম
Other side নোটিশ দেওয়া হয়েছে তো? হ্যাঁ কালকে নোটিশ দিয়ে ডিসিশন হয়েছে।
They were there, sir, yesterday.
এই জোড়াটা কবে আছে? আজ ইন্টিম অর্ডার আজকে
29th, sir.
This is for extension of interim order.
Yes, ma'am.
Who's appearing for the respondents?
Mr. Souvik Nandi yesterday was there. Upon notice
Have you served?
matter was mentioned.
Have you served?
So yesterday when the
I think so.
Mentioning was done.
mentioning notice দেওয়া আছে তো?
Sir, ওরা ছিল এটা mention.
So,
আমাকে এক্ষুনি ফোনও করেছেন বলছে আমার একটু দেরি হচ্ছে
Oh, Mr. Nandi has called
সংযুক্ত
আচ্ছা কোথায়?
বলছি যে আমার
there's strong discussion. Gupta is also.
Yes, yes.
she just called me
Souvik
5 minutes back that she's getting a bit late, so that's what she.
Delegated legislation. Let it be extended for a limited period in that.
And I'm assisting the learned advocate. She just called me the.
But learned counsels for the parties. Paragraph, let the matter appear.
দেবজ্যোতি কি তোমার নাম
It's a-
পুরো?
It's at the motion stage, no?
Yes, yes, motion sir.
As under the heading group, let the matter appear under the heading Group 1 motion. On 20th March,
Yes.
paragraph, the interim order granted earlier is extended till 30th April 2024 or until further orders, comma, whichever is earlier. For the petition, non-appeals to respondents. Next,
Eight, my lord, I appear on behalf of the petitioner, my lord. Lord, Mr. Dotto is probably is available online
yes,
virtually, my lord. This had come up on my instance for extension of interim order, my lord. My lord, the earlier interim order granted on 26th of September has been extended till time to time date, and my lord, it is extended till today. It is by subsisting.
report.
My lord,
My lord, in this case, my lord, on 24th January 2024, my lord, the meeting was held between the KMDA and the state government lordship, and the KMDA lordship had assured lordship that by 1st February lordship they handed over the part portion of the plot lordship. Until lordship they handed over lordship. If your lordship kindly give us a time lordship for 3 weeks lordship.
My lord has already, my lord, I was appearing for the
Because
petitioner. Lordship has already granted sufficient time to KMDA, to my lord, the respondent authority to produce documents, and they have
My lord,
failed to,
because
my
I
lord,
am
disclose
waiting for their
documents.
part lordship, because I am waiting for these documents lordship, because this part lordship by
Sometime.
My lord, yes, there is an interim order, but because of the pending litigation, my lord, we are not in a position to, my lord, appropriately deal with the property. So I was only praying, my lord,
my humble
if it
submission
can be, my lord,
kindly recorded this, my lord.
Destroy as a last chance.
My lord,
as a last
and my lord,
chance, and the writ petition can be, my lord, heard out next week, my lord. Kindly, my lord, if the writ petition can be heard out next week, my lord.
we have filed our report.
Learned
We have
counsel
filed our
for the-
report disclosing the fact.
Learned Counsel for the National Highways Authority of India seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, as a last chance, the prayer is allowed.
My lord, only lordship kindly recorded this portion lordship, because on 24th January lordship there was a meeting was held between the lordship KMD and the state lordship. Kindly lordship, otherwise lordship I am not in a position lordship to get any instructions on this. Kindly lordship, kindly recorded this, my lord.
যেখানে বললাম to submit on the ground that ওর সাথে add করুন আগের লাইনটা on the ground that a meeting was held between the KMDA and the NHAI on 24th.
But state lordship, the state lordship on 24th January.
On 24th January 2024.
Lordship, Lordship, on that date, Lordship, their meeting was assured, Lordship, the KMD has assured us, Lordship, by 1st January, 1st February, Lordship, they handed over the part portion of this plot.
If you records this, kindly record that I do not have
Yes.
And in the said meeting, cholche, the KMDA gave an assurance that they would make over portion of the plot in question.
Lordship, 3324 part portion, 3324 plot, subject plot.
Bracketed likhun 3324 part in favor of the state on 1st February 2024. Paragraph, learned counsel for the KMDA submits that he has no instructions in this regard.
My lord, in favor of the NHI, my lord, instead of state, my lord, in favor of the NHI.
Favor of the NHI
By 1st February.
by 1st February. NHI by 1st February. No instructions. Paragraph, let the matter appear under the same heading on
My lord,
But may it be next week, my lord.
2nd April, not same heading, under at the motion stage.
My lord.
Under the heading Group 1 motion. 2nd April 2024, paragraph, the interim order granted earlier is extended till 30th April 2024 or until further orders, whichever is it.
My lord, instead of April, Lordship, it is possible in the month of March, my lord.
You asked for 3 weeks.
3 weeks, my lord.
At the end of March, we have holiday. There are quite a few holidays this month.
Grateful, my lord.
9 I am for the petitioner. The petitioner has challenged section 26(2) notice, which was served upon the apartment, not for a juristic person, it was state. Now, they have used an exception, my lord, disclosing certain documents from which it appears not the land was not acquired in accordance with law, because
Have you
possession
used that exception?
exception, my lord, it's ready, my lord. On Monday I'll affirm it.
My lord, my humble submissions, Lordship, if your Lordship kindly give a very limited period of interim order, because Lordship, in this case, Lordship, I am facing a contempt in another matter in coordinate bench, my lord. I am, my lord, because the officer has been called for time bound within the May, Lordship, have to complete this project.
If the acquisition is not in accordance with law,
Lordship, my submission
directs
regarding
removal,
this, if your Lordship,
everything goes.
everything is goes. But Lordship, my humble submission, Lordship, they are aware of this notice, they know the fact.
Because-
Only Lordship, the instead of this apartment, Lordship, their petitioner's name came, Lordship. Only this must change. After Lordship,
And service are two. I have
Acquisition itself is bad. I'll show from their report.
service are two different things.
my lord, they know, Lordship, they suo moto handed over the Lordship, they suo moto came and made their objections.
No
I-
objection
I
has been
was saying-
filed.
yes,
Only at
that's my petition.
23.3, we have disputed the title of the central government. 26, no objection has been given because it was not served upon us.
Lordship, kindly treat these objections at their
How can
representations.
it be done?
And so that without any recent order.
I'll fix a date for hearing.
Very
Let the
short, Lordship, because
let the
we are facing
exception come. Learned counsel, learned counsel for the petitioner to seek the extension of time to use the exception to the report in the form of affidavit submitted on behalf of the NHI. Paragraph, let the matter appear under the heading Group 1 motion on 11th March.
11, my lord. I shall come back.
Paragraph, the interim order granted earlier is extended till 31st March 2024 or until further orders,
Deep love.
whichever is earlier.
11 March. I shall come back. Well, so far as item number 7 is outside is here.
My lord, I
Mr.
sincerely miss. I was,
No, number you.
my lord, I'm led by Mr. Nondi also.
It has been extended for a limited period.
Yes, but that vacating application, my lord, there was some mistake they had sent from Delhi. I
I'm
printed.
sorry, madam, I'll not allow you to mention, make your, I'll record your appearance, that's all. You can't move that.
No, 20th when it comes, I will place
do
the
that.
application.
And serve an advance copy, please.
Yes, my lord.
No, at item number 10, Lordship, I'm for the petitioner. No, Lord, this is an extension of interim order. No, Lord, there's a direction for filing a report, and also please to pass an interim order.
Yes,
But I've served the notice before mentioning.
he's appearing.
My lord,
Mr.
Prati Prakash Chatterjee and Nilanjana Banerjee, you have served the notice, my lord.
Sir,
Yes, before mentioning, I have served.
none appears for the respondents despite service of notice. Paragraph, let the matter appear. No report in the form of affidavit is also filed. Paragraph, let the matter appear under the heading Group 1 motion on 14th March.
But-
The interim order granted earlier is extended till 31st March 2024 or until further orders, comma, whichever is served.
My lord, only one thing, Lordship, in spite of your Lordship's specific direction and interim order, certain illegal activities have been committed by the, my lord, the respondent authority. But I compelled to file a contempt application in this matter. Let the contempt application be added with the main
The
file.
number,
My lord,
এটার সাথে একটা contempt application আছে, একই সাথে রাখবেন পরে।
well, may I sub an advance copy to them?
Since it's a contempt application.
Much of.
হ্যাঁ, হ্যাঁ, হ্যাঁ। হ্যাঁ, হ্যাঁ, হ্যাঁ।
14th March.
CPA method. Next matter.
March. I'm for the state.
Pursuant to the Lordship direction, today the direction to
Already raised by the respondent authority and cut down by the lordship. The civil suit is still pending. The partition suit is still pending.
Yes, taking all the views, they taken the point, respondent stated.
2/3 part has been disbursed.
Yes, Lordship.
1/3 is.
1/3 is mine. That was not disbursed.
Yes, Mr. Dhar, how do you explain this?
Now, my lord, kindly come to page 82. Order has to be read as a whole.
Yes, page 82.
There are two components. One is share, another one is who is in possession for the damages. If somebody is enjoying the entire area, damages he is to get. Now, kindly come to the page 82. The petitioner claimed that they are group 3 of the shareholder in the impugned order of the undersigned share should be 33%, and this 33% share is to be given to them. They denied to receive the share which was awarded to them as per the proportionate share of possessed area in the acquisition portion of land. Kindly mark the possessed area. They have submitted written statement accordingly on 6th November 2017. Only 4.60 decimal land out of 19 decimal of the plot number such and such was acquisition for widening of NH such and such. In this 4.6 decimal, the petitioner group had possession only on 0.78 decimal, which he is not submitting. Now, my lord, this area of 0.78 decimal out of total acquisition area, 4.60 decimal is only 17%.
And this is not in dispute.
No, this is not in dispute.
Then how can you claim more than 17%?
Lordship,
You cannot claim.
I have the share.
Partition is in respect of the entire area.
Yes.
Not only the acquired portion. Out of the acquired portion, your portion, 17% of your portion has been acquired.
Lordship,
Entire acquired portion is 4.60.
Lordship, since the partition.
Acquired portion, let us come to arithmetic. Entire acquired portion is 4.60.
Yes.
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 In that 4.60, your portion was 0.78, which cannot be 1/3 of 4.60. Right? You can claim 1/3 in the partition suit in the entire plot, not in the acquired portion of the plot.
But in respect of page number 47?
47 is not there, forget it. 47 has been set aside.
Lordship, then my lord, may I submit one thing? Let me accept the 17% if I proved in the civil court that I am entitled to get 33%. Rest of the amounts they will pay accordingly.
That has in fact no nexus with the acquisition, I believe. The partition suit is between 3 groups, each group claiming 1/3 share, right? That is the entire property. We must understand one by one. Out of the entire property, only 4.60 was acquired. Which means maybe more share of group 1 was acquired, lesser share of group 2 was acquired. The shares of acquisition were not the same.
Subject to your lordship.
Acquisition was not equal from all the shares. Right?
May I submit one thing? Subject to your lordship correction, when the property is not partitioned, I have the right over the property of 33%. If the property is not partitioned.
If that be so, you have to wait for the partition decree.
Lordship?
If that be so, you have to wait for the partition decree.
Then that's why I'm saying that lordship kindly give me that liberty to that if I prove that I have a 33%.
Other co-sharers are not before my lord. So that direction, my lord, in their absence cannot be given.
They are party in this proceeding. They are not appearing. They are party in these proceedings.
In the writ petition.
Yes, lordship. They are party.
Party kina dekho.
Yes, lordship.
Party kina.
Page
kindly, my lord.
Page 6 onwards. Respondent number 8 to my lord. Kindly see. 8 to 23.
Yes, they are party, my lord. Now, my lord, the next question would be, my lord, whether they have been intimated, duly intimated. Then, my lord, that order may be passed.
Running long for the list. They never appear.
Intimated, because generally I do not take up matters without intimating the opposite.
So is the share of company in that order?
They've not appeared all through.
Yes, Lordship, never appear.
They've not appeared. So you are agreeable to take this amount without prejudice.
Yes.
You can claim further amount subject to the result of the partition suit.
Subject to the.
State has disbursed the entire amount, excluding the 17%, which he is now willing. So, my lord, if he is successful in near future before the civil court, then, my lord, the respondents are duty bound, private respondents are duty bound to.
The apportionment.
Yes.
State with that case. Apportionment.
State has got nothing to do.
No, Mr. Dhar, the law is the state has to do it and recover.
No, my lord,
Not between the
in
private
respect of payment being made, if there are rival claimants,
State has withheld 1/3 on the basis of the partition suit. State ought not to have paid the remaining 2/3 during
and
the
if
pendency of the
state
partition suit.
has out of pocket of the entire awarded amount, they
State's responsibility. The state should not have done that. What is the basis for withholding one share and disbursing the two other shares? Can you explain?
well, regarding that, he has to, before the passing of the award, or after passing of the award, he has to notify the state authority that your award is, well, prior disbursement, before, well, after the award is made.
State has no responsibility.
Well,
Anyone goes in
until
after
unless
them-
claim comes, until unless objection comes before the authority,
It is reciprocal, Mr. Dhar. Petitioner has a responsibility, state has an equal responsibility. And when the state withheld 1/3, the state was at that moment aware that 2/3 is also involved in the partition suit. State should not have, it was rightly observed by the court in its
Yes.
bench. It should have been
well,
referred.
my view is the authority should have
The state has done that.
should
for
have
their own risk and peril.
should have relegated the entire matter before the
Absolutely.
competent civil court.
Sure, yes. They have not done that. They have disbursed 2 shares, withheld 1 at their own risk. So you cannot exonerate them. They
No.
are responsible.
If the state won't be able to pay, well,
State has
twice,
to cover.
well, then
That's the law.
yes.
You cannot leave it to the private respondents to fight among themselves. Let me dispose of 1 and 3 is on consent in that case, right?
1 and 1 and
I'm sorry, not 1 and 3, it's 14 and 16.
14 and 16.
14, Your Lordship, kindly, just I'd like to point out the relevant portion of the order as regards their objection. It's at page 48.
In which matter?
In 14.
14?
3H রেফার করে নিয়েছি তো আর কি হবে
The
14 is
case number
9187.
2918.
Yes.
The last paragraph.
Page?
At page 40. Take it. Probably this is right.
Now, my lord, before, my lord, dictating the order, my lord, in my case,
Give me a minute, please. Page
Alright.
48, I'm on in 14 now. Yes,
আচ্ছা,
page
তুমি
48.
তোমারটা বলো না।
The last part. That's why it's probably needs to be referred.
This is again a private dispute of cheating. One co-sharer allegedly cheating the
So
other.
the petitioner is.
So let the court decide. Let the
Yes,
civil court decide.
that is right.
I'm not going into merits at all.
বলো না।
15 or 16 is same order. Number to দিয়ে দেবেন আলাদা করে। WP এত which WP এত 14 or 16. Heard learned counsels for the parties. Paragraph. The petitioners seek liberty to submit an application under section 3 capital H4. আর আগে করে। heard learned counsels for the parties. It is not in dispute that the petitioners are co-sharers in respect of the plot in question.
তোমারটা ডিকটেশন দিচ্ছেন হ্যাঁ তাহলে মানে একটু আলাদা আমারটা একটু ফ্যাক্টর আলাদা
Your prayer in 14 is different. Your prayer is for setting aside the order dated 8th August
Yes, Lordship,
2016.
that and I know, but
This is your modified prayer.
I know that.
All different prayers which have no connection with the present prayer.
even in my petition as well.
So admittedly, you are co-sharers and the partition suit is pending. That is admitted, right?
Partition should be instituted by me. No.
And a partition suit filed by the petitioner in
এইটা হয়েছে number
WPA 29187 of 2017 against the co-sharers.
Partition suit is pending in respect of 28480.
Not in 29187.
There's no averment in the petition with regard to partition. There is no averment also.
এই পড়ো এইটা খালি পড়িয়ে দিও এই জায়গাটা আমার এই যে কালারটা মানে উইথ ইউর লর্ডশিপ স্লিপ মে আই
পার্টিশন সুট করা দরকার ছিল আরেকবার বলুন এই পার্টিশন সুটের জায়গাটা কেটে দিন and plot in question, comma, 4.6 decimals of which have been acquired for expansion of National Highway number 34. The petitioners seek to submit an application under section 3H4 of the National Highways Act 1956 before the appropriate forum for apportionment of the compensation declared by the authority in order to enable them to receive their share of compensation. Stop. In view of the above, comma, the writ petitions are disposed of with liberty to the petitioners to submit comprehensive application before the competent authority for reference of the same
May I take leave, sir?
to the
Lordship,
principal civil court
may I
of
take leave?
original
May I take leave?
jurisdiction, within the limits of whose jurisdiction the land is situated. Comma. Within 2 weeks from the date of communication of this order, stop. The competent authority, comma, being the respondent number, who will refer? Special land acquisition or the additional land acquisition? Who will refer the matter?
The ADMLA, Your Lordship, respondent number 7, the competent authority.
Being the 7th respondent herein, is directed to refer the application to the principal civil court of original jurisdiction within 2 weeks from the date of receipt thereof. It's only reference. It can be done within 2 weeks. There shall have been order as to cost, since no applicable, you will file within 2 weeks, and within another 2 weeks it will be referred. Now we come to the second matter, the item number 15.
Uttam Dev versus State of
WPA 28480 of 2017. Written instructions submitted on behalf of the state respondents is taken on record. Paragraph. Heard learned counsels for the parties.
Kindly comes to once page 83, second and third paragraph.
The petitioner is accepting this amount now. If he succeeds, he will have liberty to prefer enhancement. It is not in dispute that out of the total acquired area of 4.60 decimals of land, comma, the petitioners were in possession of 0.78 decimals. This is admitted. 0.78 decimals, which amounts to 17% of the total acquired area. Stop. See. Earlier, the prayer of the petitioners for
76
disbursement
597.
of 1/3 share of the compensation was turned down by the additional district magistrate within bracket LA and competent authority, comma, NHAI, comma, Nodia, by an order passed on 22nd March 2017. Stop. The said order was set aside by a coordinate bench of this court by an order
5/9/2007.
5th September 2017 in WP 10387 within bracket W of 2017. Stop. In the said order, comma, the learned court directed the authority to disburse the share of compensation to the petitioners after giving the petitioners and the private respondents therein an opportunity of hearing. Stop. Pursuant to the said order, comma, the competent authority, comma, NHAI, comma, upon granting opportunity of hearing to all the co-sharers, comma, observed in an order passed on 6th November 2017 that though the petitioners might have ownership of 33% of the total 19 decimals of the plot, comma, they were in possession of 17% of the acquired portion of the plot, amounting to 4.6 decimals. And are entitled to compensation for the said area only. Stop. The authority directed payment of the petitioner's SL for apostrophe share of compensation. Directed disbursement of the petitioner's share of compensation. SL for apostrophe. Payment of disbursement. Paragraph. Learned counsel for the petitioners, learned counsel for the state respondents submits that though 17% share of the compensation was offered to the petitioners, comma, they have refused to accept the same. Paragraph. Learned counsel for the petitioners submits that the petitioners are agreeable to receive the said compensation amount without prejudice to their rights and interest. Stop. In the event the petitioners are able to substantiate their claim in the pending partition suit, comma, they seek liberty to take necessary steps for enhancement of the said amount. Paragraph. In view of the above, comma, the writ petition is disposed of with liberty to the petitioners to accept the 17% compensation as offered by the respondent authorities without prejudice to their rights and contention. Stop. The petitioners shall be at liberty to claim further compensation commensurate with their share in the plot in question, subject to the result of the partition suit. Disposal of policy. No order is to cause or exact length. Yes. Next.
Next, my lord, same as regard of 14. 14 and
Again, prayer is different and your present prayer different. I just take the 5. 17. What? Item 17.
Item 17, I am for the petition. But on the last occasion, they have taken time only one instruction, whether this road will be demolished or they will give the compensation, crop compensation and land compensation. Only for that. This is the road, Pradhan Mantri Sadak Yojana, there is no.
I am appearing for Jala Parishad. Learned advocate Mr. Sandeepan Banerjee is busy with another matter at court number 19. A little password may kindly begin. Short
This is the only instruction from, this is the 5 days they have taken time. Only instruction. Your Lordship has already completed the hearing. Either you give the compensation or demolish the road. All the roads have been.
Yes, there are 2 options left.
Yes,
And it is for the Jila Parishad to decide.
yes, Jala Parishad will be.
Not today.
But how,
Today. Come back tomorrow.
how many days is that?
Tomorrow, please. That's why I've made it not today. Please be ready tomorrow. No excuses tomorrow. Next.
18. I beg to appear on behalf of the petitioner before your lordship. Milord, your lordship was pleased to pass an order on 4th September 2023, Milord, for joint inspection, Milord, and it was held, and report also was submitted before your lordship. What I am on today, Milord, your lordship kindly allow me to file those documents by an affidavit, and some exception also is there, Milord. I shall bring it to the notice of the honorable court, Milord. That is why, Milord, some time may be granted to me, Milord, for filing that affidavit.
Supplementary affidavit.
My lord. The lapses, my lord, I have gone through the report, my lord. There are some lapses. I shall bring it to your lordship's notice.
On prayer of the petitioners, liberty is granted to use a supplementary affidavit annexing relevant documents. Please
My
serve
lord.
an advance copy, madam.
My lord, certainly, my lord, I shall.
Paragraph, let the matter appear under the same heading. April?
No, March, within March, my lord. I shall, next week I shall serve it.
27th March.
My lord, 27th and 28th, accepting that your lordship kindly make it, my lord.
Will the court remain closed on 27th and 28th?
But any day except on 27 and 28 will I would not be able to come.
22nd.
22nd. It gets with you, Lord. Deeply obliged.
Next.
27.
No, why should 22nd.
Because everyone is refusing 27, 28. 19.
99 for the petitioner.
Your Ladyship, I am appearing on behalf of respondent number 7, ma'am.
I'm appearing on behalf of National Highway Authority. I'm led by Ms. Monica.
My lord, in their report, my lord, the block level.
State.
My lord, Mr.
Yes.
the other 2 days also.
For the state.
Yes, my lord. My lord. I'm led by Mr. Shishana Bandavad.
Yes, my lord. My lord, both my lord, that in 2 reports they have accepted, and my lord, that the land for the petition has been utilized, particularly plot number 2018 and 9. Well, kindly come, the affidavit affirmed by respondent number 7, the report, where they have categorically stated that para 4, bottom.
Have the pipelines been shifted?
No.
Some portion of the land, the existence of the pipeline, and we are willing to shift. Kindly come, ma'am. My lord, page number 8, annexure R2.
Of your report?
Yes. Yes, my lord. Yes, my ladyship. Your ladyship, the only concern is right now, your ladyship, is that some portion of the land is adjacent to the National Highway Authority. So before shifting all those pipeline, we require some kind of cooperation from the National Highway Authority. And this is a difficulty right now for us.
Page 8 of your report, you said. This
Page-
is a letter to the assistant engineer.
Yes, the heading is the subject is the shifting of the pipeline.
Yes.
Thereafter, my lord, the plots were inspected. Pursuant to their, my lord, the prior your lords allowed them, the BLRO, to demarcate the land. They demarcated the land, and they, in their report, categorically stated the entire portion of the lands of the petitioners, particularly 2 plots, have been utilized. My lord, I shall place that, but perhaps my learned friend also place that.
Yes.
That
Your ladyship, if I may indicate my ladyship, just kindly come to paragraph number 9 and 10 of my report, which is page number 5. That the respondent number 7, they installed the pipeline in some portion of the land in question, and for which the earlier report was filed for restoration of the said water pipes. Accordingly, there are the correspondent with the National Highway Authority, and till no date, the permanent solution has yet been reached. And from the report of the concerned BLRO contact, some confusion has been cropped up regarding the land in question, where the water pipe lines has been installed, belong to the predecessor of the petitioner or not. For proper verification and to ascertain the truth, respondent number 7 required more time and undertake to file further report in terms of the solemn order and direction of the Honorable Court.
Further ascertainment is required.
My lord, for that we read,
Admittedly, you're
my lord,
utilizing the petitioner's land.
yes, my lord, one thing just we need some report from the National Highway Authority to some question which has cropped up, my lord.
What are the questions that have cropped up?
That I have to take instruction, my lord. My lord, I will be requiring some time. You just permit me like a 3 weeks time so that the National Highway,
my
because
lord,
depend on the National Highway Authority to give us the answer.
My
We have
lord-
already communicated
My
what we
learned
require.
friend, read my lord paragraph 9, then come the paragraph 10 of the report.
Yes, I've seen that.
You will have to see it. That I, on behalf of the respondent number 7, submit that due to the inherent circumstances and not getting through picture from the acquiring land acquisition authority, Puro Medinipur, construction said, authority, the final decisions for restoration and making compensation could not be arrived at and accordingly it is humbly paid. The grant some more time to complete. It is February, the report. Paragraph 8, they have stated with the my lord, the paragraph 8 kindly see. The showing the location of pipelines as installed in some portion of the land in question as involved in present petition, and a major portion has been utilized by the PWD Puro Medinipur. They admitted the PWD utilized this thing.
So you are the authority, PWD.
And then my lord, kindly come the report, the report of the my lord, the report in the form of the letter which has been submitted to lordships. Well, kindly come the report of the BLLR.
At page?
My lord, at page, my lord, first, I'll kindly come, para 1 and 2. First page, my lord, this is the report. The report dated 16th December 2023.
Of the
BLLRO,
to the executive engineer of Tomlu, your
Yes.
ladyship.
oh yes, yes.
Where we have marked, we have indicated the pipelines as well, your
that
ladyship.
the LR plot number 907 of Mouja Satin Sat is not involved with the pipeline of PHE department. There is no existence of the pipeline. Then 2, that the LR plot number 908 and 909 of Mouja Silbudi are involved
The pipeline
with the pipeline of the PHE department. Then my lord, kindly come the Bengali after one page thereafter. This is the report of the revenue inspector. My lord, kindly come 4 and 5.
Yes, so it is admitted.
He admitted that.
Why do you require further time?
My lord, we just need some proper
and also they have given the
verification
picture.
from the
Kindly see
NH.
the
This
map.
has nothing to do with NHAI.
My lord, if I may indicate, my lord, humbly,
Utilize the petitioner's land.
but the some portion of the land is adjacent to the National Highway Authority.
Matter. The petitioner's land. It may be
Yes,
adjacent to
yes,
someone else's
yes, your
land.
ladyship. Yes, your ladyship.
That's not really relevant here.
But if some
And
because
also,
we
my
want
lord,
to, because the question arises in, my lord,
and
we
also
have
my lord,
put
kindly
it.
come the map.
Where is it stated that it is adjacent to NHAI's property? I do not find it.
My lord, paragraph
They
number.
admitted. They also annexed the pictures of the map. Entire my lord, kindly see the yellow and color that is in the middle of the two plots. They have installed the pipelines. Causing entire damages to two plots. And they've also annexed their report.
My lord, we are not denying the fact that we are not going to shift. We want to shift the pipelines.
Cannot be indefinite, isn't it?
Yes, your ladyship.
Going on for quite some time.
But we,
in fact, since 2019 with petition.
it's
these orders have been passed since
2024.
2021.
I won't, my lord, I won't stand in the way of the order, my lord. I will humbly accept the
One
order.
week's time to remove.
My lord, just take the, if we need some cooperation from the National Highway Authority, as we have indicated,
National Highways, yes, what is your submission, madam?
because we have written letters, that we need the cooperation from their side.
What kind of cooperation do you require? I'm asking that. I don't think you don't require any kind of cooperation from the NHAI. What cooperation do you require from NHAI? Where is the letter? Please show me. Your correspondence with the NHAI?
My lord, that haven't been
I
annexed.
do not understand how the NHAI can cooperate. Is the petitioner's land need to shift the pipelines from there? Please do not complicate simple matters.
Yes, sir.
The plots are adjacent to NH 116B. So,
Because when we have demarcated your leadership, that the officials of the initial National Highway Authority was also present at that point of time when the demarcation is previous.
petitioner cannot be made to suffer for this.
My lord, this
Madam, what do you have to stop, sir?
Lordship, in this matter, we are not the main answering respondent. The PWD is the main answering respondent.
Over. So please take a call. I'll grant you 2 weeks time as you say, but then
just give me 2 weeks time. I will get
so that
proper instruction. I will come back. I will get
instruction. Please do the job, sir. Instructions will not help. Instructions are already there on record.
The land, but my lord, in 2 plots, 90866 decimals, one decimal, and fully damages, my lord. But the water land they made.
To pay damage compensation, yes.
Yes.
You have to remove the pipelines and pay damage compensation.
Ma'am, I'm just praying for the 2 weeks time. Just get me proper instructions regarding this things. Then I will be in a better position to assist the honorable bench.
Third learned counsels for the parties. Paragraph, it is not in dispute that the PWD has laid pipelines through the plot of the petitioner, though the plot was not acquired, nor any compensation paid. Paragraph, learned counsel for the you're the 7th respondent.
Yes.
7th
Yes, your
respondent
leadership.
seeks accommodation to take necessary instructions with regard to the subject matter of the writ petition. Paragraph, let the matter appear under the same heading on 19th March.
Grateful, your
Paragraph,
leadership.
it's expected that the 7th respondent shall take necessary steps within the adjourned date for removal of the pipelines from the plot in question, as well as payment of damage compensation to the petitioner.
My lord.
My lord, I'm whether the instructions, let me put the instruction first.
Instructions, my lord,
Instructions
4
on
and
record.
5
We do
occasions.
not need any further instructions. The job has to be done now. To remove and pay damage compensation. There is no third option. I have recorded this so that I can draw up a contempt proceedings. Please
Great.
inform your clients. Next matter.
20.
On the last day, Milord, citing the
Your Lordship, my senior Mr. Satyajit Talukdar is appearing for the KMDA. He is engaged in court number 15, Your Lordship.
only the urgency is that, Milord, on the last day, Milord, Mr. Talukdar has taken a point that the substitution application has not been, Milord, served to him. Milord, the substitution, now, Milord, everyone is served, Milord, the both affidavit of services before your Lordship.
So, this is under the 62 Act.
Yes. Milord, what happened, Milord, for the part, Milord, the state Shishorna Bandopadhyay. Mr. Bandopadhyay has also been served pursuant to my Lord's last direction. Milord, what happened? Milord, I approached before this honorable court by filing the present writ petition. For Milord, my land is being acquired for the purpose of construction of Kona Expressway. Milord, after the utilization of construction of the Milord road is question, there is a strip of land, Milord, left in between my premises.
And one is your substitution of it?
Yes, yes.
Yes.
Where did you file? When did you file it first? And one of 2023.
2023.
And 2 of 2024. There are 2 applications.
Yes, Milord. Second one is for injunction since, Milord, I prayed for removal of encroachment. In the meantime, they are making a mandir over there. Milord, a temple is being yes.
But can one, where did you file it? It's not here at all.
আমার কোথায় কেন মনটা দাও আমাকে The can 2, can 1.
Can 1.
What was it? Procedural service. Can 1 also. But can 1 is for substitution within time.
It's not on red letter.
But this is the copy of.
Let the department send the application. Can 1 of 2023 is not in the file. Paragraph affidavit of service name. Paragraph, the department is directed to put up the said application along with the file on the adjourned date. Paragraph.
But my drainage has been blocked, not kindly.
Give you very short.
Yes, Lord.
And let the matter appear under the same heading on 7th March.
7th March.
Next issue.
Great. But the affidavit of service. Great.
21, my application. Your Lordship, I'm for the petitioner. Your Lordship would kindly straight away take page 37 of my writ petition, Your Lordship.
Your Lordship. State is the only respondent.
State is the only respondent, my lord. His grievance against the PLR order.
Your Lordship,
That is
may I?
the
May,
challenging
may I please?
prayer portion.
Your Lordship, at page 37, Your Lordship would find that this is a.
7?
Yes, Your Lordship. This is an order. This is an order passed in appeal from an appellate decree by the Honorable High Court, Your Lordship. Your Lordship, the operating portion of the order is at page 57, Your Lordship, wherein the court held that the subject land is not vested, being tank fisheries, Your Lordship.
This is 26th May 2006 order.
No, Your Lordship. At page 57, Your Lordship would find the operative portion of the
order impugned.
No, Your Lordship. I'm coming to that, Your Lordship.
Order impeach, page 85.
Your Lordship, I'm coming to that. Your Lordship,
85,
in short, Your Lordship, I want to state the facts first. Your Lordship, in the appellate, the High Court in second appeal held that the subject land is not vested, and thereafter, Your Lordship, we filed a writ petition for mutation in the record of rights. Then, Your Lordship, BLLRO says that that the order of the High Court is incorrect. High Court has overlooked another decision of Supreme Court, and that's why he cannot enforce. Your Lordship, the state did not file any appeal from the appellate order of the Honorable High Court, and the order became final and binding. Can the BLLRO sit in appeal over the High Court's order? And Your Lordship, that's why the second writ petition, Your Lordship.
The present writ petition.
Yes, Your Lordship. Present writ petition.
Which is the order of the
Your
BLLRO?
Lordship. Your Lordship, order of the BLLRO, Your Lordship.
Start from page 85.
Yes, Your Lordship. The relevant portion is at page 107, Your Lordship.
Yeah, it is.
This is under the Land Reforms Act.
Your Lordship.
My lord, this application, my lord,
Your Lordship.
it can be challenged before the division bench with WPLF.
Your Lordship, what I only point here is, can the BLLRO sit in appeal over the?
Where is that language? I do not find.
Your Lordship, your Lordship will find it. Your Lordship kindly takes page 10. Your Lordship, I will at 105. Your Lordship. In view of the above, it is crystal clear that all the questions raised and the findings given by the Civil Court and by the Honorable High Court in second appeal were overruled by the Honorable Supreme Court in their judgment, as already mentioned. Your Lordship, this is not an appeal.
BLLRO is relying on a judgment of the Supreme Court.
Your Lordship, but
whatever
it is not in my case.
This court cannot deal with the matter. You have to go before the appropriate forum.
Your Lordship, appropriate forum, I have exhausted, Your Lordship.
No. You have the forum, division bench, division bench.
According to the Land Reform and
WP
Penalty Tribunal Act, you can approach
have
the
the
division bench, not the single bench.
Your Lordship.
Before the division bench.
Please go through that.
Your Lordship, will the matter be transferred to the division?
Transfer, I can release, I'll grant you liberty to approach the appropriate forum. That's it.
Nothing to face. Liberty needs to score. Liberty needs to score file.
The matter pertains to the West Bengal Land Reforms Act 1955. Paragraph, the petitioner seeks to.
My lord,
Yes.
my lord, withdraw and they for your liberty.
Withdraw and file afresh, yes.
File afresh before
Petitioner
the
seeks to withdraw the petition and file afresh and take necessary steps before the appropriate forum.
Your Lordship, let there be a direction of this honorable court, Your Lordship.
What direction?
That this
This court has no jurisdiction at all. Your Lordship. A direction can be the only when the court has jurisdiction.
Right, Your Lordship.
The court doesn't. Paragraph in view of the above, the writ petition being WPS is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no order as to costs. Next.
$22.
Appear for the respondents number 2 and 3.
I will just. Look, this was the matter. Lordship. This Lordship, just briefly to remember, this was an. My client is the owner, subject to, not owner really, under the section. This land is vested in the state under the Urban Land Ceiling Act. Section 20 exemption given to the original owner. Original owner has to run that particular industry on that plot. So transfers from that by the original owner have been on the condition that this section 20 exemption has to be followed. I am a transferee. The private respondent is also a transferee. Adjoining land. I am running a factory. Private respondent land stopped running a factory many years back, and they wanted to use it for some other purpose.
Who is appearing for the private respondent and the state?
I'm for the private respondent.
You're for the private. The
My
state,
lord, I'm
you're
2 and 3.
Very-
My lord, I'm for the authority. I'm for the authority, my lord. 2 and 3. My lord, I'm led by Mr. Chatterjee.
Now, so we made a representation which was not being considered. We came to the High Court. High Court said, let it be considered in accordance with law. To the ULC authority, that you please revoke the section 20 because that was conditional upon these. Because if it is revoked, I have a possibility of getting that land under the scheme of the government, land policy of the government. I am last in priority after public purpose. After public purpose, I come into the next category, that is adjoining nearby industry. So I made that application. That application is rejected by the competent authority on the ground that section 4C conversion has already been allowed, and also on the locus standi, my locus standi.
I think it was considered without the reports.
No, but that's the appellate authority, Mala. That's the appellate authority. So the competent authority under the Act rejects our application essentially on the ground of locus, and that since section 4C permission has been granted. Now, Mala, from that we file appeal under section 33 of the Urban Land Ceiling Act. In the appeal, after the first day's hearing, an order was made that the matter will be heard after the three documents are submitted by the authority by the competent authority, that is 4-1. Three prior steps needed to be taken. One is
Page 414. Order dated 21st January 2021. Two conditions, two.
Yes, yes.
414, the third last para and the second last para. Third last para, the competent authority and SDO Barakpo be asked to confirm whether any NOC as mentioned by ISAB has been issued from this end, from his end. And if so, a detailed report showing the basis of issuing such NOC be submitted to the UDMA department at an early date. The departmental authority would examine the matter and offer views in this regard. And two, let ULC branch under UDMA be asked to inform whether any prayer for change of purpose from welding business and ancillary to industrial park, along with DPR of the proposed project, duly vetted by MSME department, has been received and duly examined. And then on getting written statement from ISAB and report from the competent authority and ULC branch matter, branch under UD and MA department, the matter would be heard again. This order is firstly not made available to us. We write to them because no date was given. We write to them on 16th April. Nothing comes. Order copy is not available. Then on 16th April, we get a notice that the hearing is on 19th. So when the hearing happens, we point out that these reports were called for. So without the report, because the procedural order was after these reports and whatever these feedbacks are given by the concerned department, matter can be heard. But without waiting for the feedbacks, and after recording that the feedbacks have not really come, the application, my appeal is rejected again on the ground of lack of locus standi. So well, I had shown firstly that date on which the hearing is fixed, though really not exactly the same cases. If a date is fixed, if it is taken up on earlier date, then in that case the order is liable to be set aside. I had cited several judgments, different courts, including our high. Yes. But now that is in my humble submission. That should be the preliminary point. It should be sent back. Now, since the appellate authority at the admission stage considered this to be the precondition, then my locus should also be considered on the next date after these reports are there. But they had objected to locus, and your lordship also observed that you show that, I mean, also all the locus make your submissions. So on locus, my lord, I make it twofold submission, my lord. Firstly, locus standi point cannot be an appeal or a petition or whatever can't be dismissed at the final hearing stage on the ground of locus standi. When it's admitted, order is made, then at the final hearing, locus it cannot be dismissed. And secondly, my lord, though I will of course not get urban land sealing authorities, appellate authorities judgments because those are not available, but in the context of our writ jurisdiction, non-PIL, non-PIL, the locus standi test has been watered down over the years. And from 2000 onwards, anybody having some interest will be entitled to file a petition in the non-PIL section. Now, my lord, to that, I have their principal contention at that point, at the preliminary point, was that Justice Bosha has dismissed our another challenge from the Section 4C proceeding. Section 4C proceeding on the ground that I have no locus. I can't object to the Section 4C conversion permission being granted. So, well, I had shown Justice Boshak's judgment, where his lordship expressly did not deal with the ULC aspect. Lordship kindly takes a look. The ULC aspect, saying that the ULC matter will be heard by whichever bench hears the matter.
Is it 99 of 2023?
Yes. Yes. Lordship, page 24. Lordship, paragraph 51, of course, that has come on a, I mean, LK Ratna is not the ULC matter, but it's paragraph. But this paragraph 51, though LK Ratna is not the judgment for that, LK Ratna has no manner of application in the facts and circumstances of the present case, as the writ petitioner has failed to establish that any prejudice was caused to it for the alleged breach of the principles of natural justice. Moreover, the decision of the appropriate authority, the appellate authority, as well as the tribunal, are well reasoned. Now, paragraph 52, the court has been informed that there is a civil appeal pending before the Honorable Supreme Court with the Paschim Banga Bhumi Jimi. That's the point I'll be urging here. 53. P.S. Rao has held that an application for grant of exemption under Section 2020 of the ULC Act is maintainable even after excess land has been declared and such land has vested in the state under Section 10. 54. Dorothy Claire Pereira has also dealt with the provisions of the Act of 76. It has observed that under the scheme of this Act of 76, on publication of the notification under Section 10(3), and after putting a date from which the land stands vested in the state, and after publication of the notification in the Gazette, and on and from the date mentioned therein, the excess land stands vested in the state, free from all encumbrances, subject to decision in appeal, if any fall according to law. Stands vested. Now, 55. Well-wisher has dealt with the provisions of the Act of 76 in the context of an order of the competent authority, withdrawing the exemption granted under Section 20. Propriety of order granting conversion under the Act of 55 has been assailed. Infractions, if any, of the Act of 76 is not the subject matter of the present proceedings, and the tribunal has correctly held that the same is outside the purview of its jurisdiction. Consequently, authorities cited on the subject of alleged infraction of the Act of 76 have no manner of application. So, that is kept out, Supreme Court now? Copy nahi Supreme Court. Lordship, only thing is that, Lordship, may amara copy dao. Yeah. Lordship, from this order, we went up to the Supreme Court, and the Honorable Supreme Court has passed an order, even though dismissing. Lordship, may I hand up my junior's iPad? Oh, so, yes, thank you. I'm so thankful. On 16 January 24,
Yes.
we find no reason to interfere with the dismissal. However, the dismissal of this special leave petition will not have any bearing in the pending writ petition, that is my lord's writ petition. So, my lord, may I address the locus standi point with my humble request that lordship will not be influenced by the judgment of Justice Boshak. That will be my humble submission. Lordship, firstly, the distinction between Justice Boshak's case and this case is this is government land, because ULC Act Section 20 exemption is granted only if the land is excess. So, my lord, it is not a fight. Like, I am not interfering with my neighbor's land, with my neighbor's right, with the ordinary neighbor's right. So, whether my ordinary neighbor makes his building without without sanction plan or not, or without some permission fire clearance, I may have a lack of locus standi, though judgments say otherwise. But here I am on government land. The government land is being allowed to be held by my neighbor only for a particular purpose. It is like a park on a public park, or in say a public hospital in my neighborhood. In a public hospital, if I find that a private promoter is converting the hospital into a shopping mall, and I know this is on government land, a government hospital, I will have a right to come to court and say this is classified in the LUDCP as hospital purpose. This is in the record of rights for commercial bracket hospital. I mean, what one would say bastu in bracket hospital. So it can't be used for a mall. So I have a right to object because this is a government property where I also have a right. So, but for that, I am first showing, because just to put at rest their contention that Section 20 exemption does not mean that the land has not vested. Section 20 exemption means the land has vested. It is excess land, and it is only the surplus which and you're only allowed to retain at the discretion of the state. It is 6(3) of the Estate Acquisition Act or a 14Z of the Land Reforms Act, subject to even more conditions. Lordship, hold down. You will you will see money vest করে গেছে vesting এজেন্টটাকে দাও 96 Let's start with the locus first thing. Bolo. In the meantime, may I start on the locus judgments first, and then I shall come to this UL.
Placed reliance on them earlier.
Well,
The judgments are here with me.
that is for the
Locus judgments.
locus I had not, but this is not on the due date.
One is 2005, Volume 3, Supreme Court.
Yes. 5(3) SCC 683.
683.
And 2000 Volume 7 SCC
552.
552.
Yes, that's all.
15 Calcutta. All India AIR 15 Calcutta, page 112.
এই দুটো দেখানো হয়েছিল, এগুলো দেখানো
The Dhaka bar karo na 15 to bar karo.
53 Assam you've referred to.
Well, that is not on the due date. If it is taken up on a wrong date, then order passed.
Yes.
in Calcutta.
Yes. You know, Akka. AIR 2015, all Calcutta, page 112. Paragraph 1 firstly, and then 29 to 32. Paragraph 1 at 113. There is a primary question and a supplemental issue that have been referred to this full bench. Whether in view of the law laid down by the Honorable Supreme Court in Mithilesh Garg and to Supreme Court, a writ petition at the instance of existing operators providing stage carriage services on different routes who seek to challenge grant of fresh permits in favor of new operators, either on the self-same routes on which they have been operating or touching a portion of the same, by the transport authorities, ostensibly taking recourse to the theory of, to the bogey of liberalized policy relating to grant of permits under the Motor Vehicles Act. Motor Vehicles Act is not maintainable, although such grant ex facie might appear to the court to be grossly illegal, patently arbitrary, and intolerable exercise of power, consequently offending the constitutional concept of equality. So this was the issue. Same thing, whether it would be permissible for the court exercising jurisdiction. Is it permissible for the court? Permissible for the court exercising jurisdiction. Lordship kindly comes to paragraph 29.
Yes.
Several judgments have been cited on behalf of the writ petitioners that a challenge under Article 226 can be maintained even at the instance of an existing operator against a new operator if the complainant can demonstrate a legal right in his favor and the act complained of is said to be illegal. In the judgment reported 53 SCC, the court held that a person in the same trade as another whose license was sought to be cancelled could otherwise maintain a writ petition if the cancellation of the license was sought on the ground of the issuance thereof being in violation of the statute or the rules framed under any statute. In Pancham Chand versus State of Himachal, a matter pertaining to the Motor Vehicles Act, the Supreme Court noticed that a person with considerable political clout had caused his application for the grant of permits to be entertained directly by the Honorable Chief Minister of Himachal Pradesh. The Supreme Court held that the Chief Minister could not have entertained the application nor usurped the function of the Regional Transport Authority. In a more recent decision, 13.5 SCC, Rajasthan so-and-so, the Supreme Court observed that executive instruction which had no authority, which had no statutory force, could not override the law. And as a consequence, executive actions which ran contrary to statutory provisions could not be enforced. It follows that when such an illegal act is complained of, and the complainant demonstrates the prejudice suffered as a consequence thereof, his locus standi to maintain the complaint and Article 226 cannot be questioned, unless the court finds that an efficacious alternative remedy exists, and the court exercises self-restraint in not receiving the petition on such ground. In the judgment reported 2006 Calcutta 3444, the issue pertained to the several permits being granted by the STA without any applications in such regard. On a revision filed by some private parties, the State Appellate Tribunal in Lucknow set aside the grant of the permits and held the action of the estate to be mala fide, as it had acted in clear contravention of statutory requirements. Such order of the tribunal was challenged in Allahabad High Court on the ground that the proceedings before the tribunal were not maintainable at the instance of the existing promoters. The High Court found that the permits could not have been granted. The Supreme Court upheld the order of the High Court. Then 31, Lordship, may I come to 32 straight away? In the judgment reported in MS Jayaraj, an existing liquor vendor complained of a rival locating shop in a range other than for which such rival had been granted a license. The court noticed the relaxation of the rule of locus standi by the Supreme Court in the 80s and the 90s. The court referred to the dilution of the strict rule, particularly in public interest litigation, and observed that if the excise commissioner had no authority to permit a liquor shop owner to move out of the range, it would be improper to allow such an order to remain alive and operative on the sole ground that the person who filed the petition has strictly no locus standi. In paragraph 42, the dictum in Mithilesh Garg has thus to be confined to a situation where an existing operator is seen to challenge the entry of a rival in his theatre of operation on the ground of the existing operator's business or commercial interests being prejudiced. The judgment cannot be read to imply that an existing operator has no right to complain of an illegal or irregular act of the transport authorities in allowing a new entrant to operate in the same or like field. There is no doubt that it is the commercial interest of an existing operator that may impel him to challenge the grant of a permit to arrival. But if the challenge is based on the perceived irregular or illegal acts and conduct of the transport authorities, the challenge cannot be repelled only on the ground of business rival. The Motor Vehicles Act and the rules of policy guidelines framed thereunder bind the transport authorities to act in a particular manner in the matter of grant of permits or allowing insurance. Lordship, I am not troubling with this. So, Lordship, kindly come to the last page. Sorry, Madam. Page 123 only at the bottom, last 3 lines. Last 3 lines of page 123. If the complaint is of the irregular and illegal exercise of authority, which results in the complainant being affected or likely to be affected, the status of the complainant as a business rival of the beneficiary of the irregular or illegal executive largesse will not stand in the way of the complaint being received for judicial review. However, if there's a tribunal entitled to receive such complaint, the High Court next. So this is only on the ground of alternative remedy. Can I be? Lordship, another 20 minutes I'll need to finish. Lordship, next day, whenever Lordship. Wait,
মিনিট পরে অবধি যদি 20 minutes more. Very good.
Counsel for the petitioner. Paragraph, let the matter appear under the same heading for further consideration. 13th March.
Great for that.
They may be after 17th.
After 17th?
After 17th. On 18th March. 18th.
Rajiv, 18th March.
18th March. But 13th, I have some personal difficulty. That's why I was.
690. Yes.
This matter?
Yes. Yeah, ma'am. We also want to finish it.
Fairly at the top, Kurun.
Thank you.
690.
I've got the petition.
This is yesterday's matter.
Lordship. Lordship, in continuation of the yesterday's Lordship, the argument that the points I have urged, Lordship,
Were acquired.
that only 1 decimal of 2 plots,
Each of the plots.
has been acquired, and Lordship,
Hearing for the respondents.
Lordship, Lordship, the compensation also has been disbursed in respect of 2 decimal of land.
All the respondents are present. Yes, ma'am.
Now, Lordship, kindly consider some provisions of the West Bengal Land Reforms Act that in terms of Section 4, notification has been issued, Section 6, declaration has been made. Now, Lordship, Lordship, this is the fact, this is law of the land. Unless this compensation has been disbursed, no land can be utilized, cannot be utilized. And if the compensation cannot be disbursed within a period of 2 years, the entire acquisition process will be vitiated, will be lapsed. This language has been used. And kindly consider the Land Acquisition Act, Lordship, 1984, because this land was acquired under 1984. Or 1894. I'm sorry, 1894.
Give me a minute. Yes. Yes. You're referring to section 4?
Lordship, no, I'm just placing, kindly come first section 16. Section 16 তোমার কত? আমাকে দিল copy?
No.
Kindly come section 16.
Yes.
Lordship has the book. I have alternative. Yes, acquisition is complete.
That part of
Acquisition complete. What is the?
only 2 decibel, nothing else after that, nothing else.
No, my lord, there is the
Let-
dispute. This is the dispute. My lord, kindly allow me 1 minute.
No, let me. I have not
Yes,
completed.
he will tell. 30 seconds, my lord.
Completed.
30 seconds, man. 30 seconds, my lord. 30 seconds.
Let section 16 place.
No, he's telling now there is 1 decimal, my lord. That is not the fact.
Get your turn, sir.
Yes, ma'am. Yes, ma'am. Yes.
Also, kindly come section 16.
Yes.
When the collector has made an award under section 11, he may take possession of the land which shall thereon vest absolutely to the government free from all encumbrances. Now, Lordship, kindly come section 48.
Yes.
Lordship, completion of acquisition not compulsory, but compensation to be awarded when not completed. Except the case provided for in section 36, the government shall be at liberty to withdraw from the acquisition of any land of which possession has not been taken. So, Lordship, possession has not been taken. Now, Lordship, the acquisition process automatically is withdrawn. There is no such notification is required to be issued that these are the lands are not within the ambit of acquisition. Now, Lordship, kindly come. The acquisition
Not automatically withdrawn. There has to be a notification.
there is no such required notification. Lordship, I am just relying upon one of the provisions where, Lordship, the acquisition process will be lapsed if, Lordship, the compensation is not paid within a certain period. Section
11A.
11A. Lordship, kindly consider 11. Yes, 11. Period within which an award shall be made. The collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration, and if no award is made within that period, the entire proceedings of the acquisition of the land shall lapse. So, Lordship, this acquisition process shall be lapsed. It is automatic. No requirement of notification is issued. It appears from the reason order. I have, Lordship, cited that repeated occasions the authority has held that no notification has been issued that this except 1 decimal of land, other land has been acquired. And Lordship has been exempted from the purview of acquisition. Lordship, repeatedly occasion this observation has been held, which is absolutely contrary to section 11A. And Lordship, not only that, Lordship, the compensation which is supposed to be issued, Lordship, in notice, that is section 11, inquiry and award of the collector, all are in respect of 2 decimal of land. Now, this is the one aspect of the matter, and another is, Lordship, kindly consider that yesterday I have submitted, Lordship, what is the definition of land under the, Lordship, the Public Premises Eviction of Unauthorized Occupants Act, 1971. Kindly see what is the definition of, Lordship, the premises. Premises means any land or any building or part of the building includes the garden. Lordship, kindly see section 2. Madam, it would deem. Yes, it about 140, it about kindly see the definition of section premises.
Yes.
So this land is within the meaning of the, Lordship, the railway central government land, and if any acquisition, if any unauthorized construction is made, that can be evicted from the
after the initiation of proceeding under Section 4 of 1971 Act. Now, Lordship, without providing this, without adopting this procedure, straightway, Lordship directed to evict this unauthorized construction. Lordship, this is the one thing. And another thing, Lordship, that this is the judgment of these several courts, that when a procedure has been laid down, Lordship, that procedure has to be followed, or otherwise Taylor versus Taylor, Lordship, kindly appreciate that when a procedure has been adopted, has been required to be followed, that procedure has to be followed or not at all.
Settled law.
This is settled position of law. Lordship, I'm relying upon the Taylor versus Taylor judgment. And Lordship, kindly come the Railways Act, on the basis of which this proceeding has been initiated. Lordship, kindly Section 148. 147. 147 of the Railway Act. This is not at all applicable in this present case. 147. Railway Act আছে? এই আমার বইটা দাও। Lordship, I have a book.
It is there, right there. Yes.
আচ্ছা। Kindly come Section 147.
Yes.
Trespass and refusal to desist from the trespass. Lordship, it appears that if any person, Lordship, can the first word, if any person enters upon or into a part of the railway without lawful authority or having lawfully, Lordship, entered upon or into such part misuses such property or refuses to leave, he shall be punishable with imprisonment for a term of such and such. Lordship, this is in respect of an individual if he enters unlawfully in the railway properties. Now, Lordship, kindly come. Again, I'm just praying, Lordship, the order of the Honorable Chief Justice I have annexed. 177, page 177.
Clear order to,
Kindly come page 178. It's the relevant part. I'm just Lordship, yesterday I placed this order. Again, Lordship, I'm giving trouble. Pay paragraph 5.
Yes.
Page 178. Therefore, we direct fourth respondent, that is the railway authority, namely Divisional Manager, Southeastern Railway, Kharagpur, Paschim Mednipur District, to inquire into the matter by himself. Lordship, got it? Or by the officer who is empowered to deal with the matter and issue notice to the private respondents, call for the necessary documents and examine the same if it is found that there is any encroachment on the railway. Now, Lordship, kindly come paragraph 8. This paragraph 8 has been totally flouted in passing the order. Kindly come paragraph 8. This aspect, this matter, shall also be examined by the Divisional Railway Manager or such other authority as the Divisional Railway Manager may nominate, since the assistance of the revenue authorities may be required. Lordship, got it? Required. The Divisional Railway Manager can seek necessary assistance from the District Magistrate Howrah, who shall nominate the appropriate officers of the Revenue Department to assist the process of inquiry and for demolition of the identification of the property in question. Lordship, kindly from this impugn order and the notices, not a single notice has been served, neither upon the District Magistrate nor the Revenue Officer, nor, Lordship, no state government acquisition officer has been intimated that this is the proceeding is pending, and so no assistance has been called for from the state authorities, acquiring authorities.
In the hearing also.
In the hearing also, the none was present. Lordship, kindly I've come to the notices. Kindly come to the notice, Lordship, I have annexed. 196.
That was assumed in the earlier petition.
In consideration earlier, that is the order of the Honorable Chief Justice to take assistance, but none of the state.
Only Bharat Chakraborty was.
No state authorities were present in the hearing.
ছবিটা পরিষ্কার করতে পারি না
বললে হবে, টাইপ করতে হবে। পরিষ্কার আছে? Lordship, kindly come to the notice 194 and 195 and 196. Lordship, not a single notice has been served upon the state authorities for taking assistance. 197, na? কিছু বলার আছে?
Yes.
So these are my respectful submission.
The railways will make a submission first.
Yes, my lord. I have a small submission, my lord. Fact of the case, my lord, is the LA case proceedings being 14 Act number 1 of 1961-62 initiated in Act 1 manifest that for the construction of Maurigan and Dankuni link project in the village of Dolia, jail number 35 PS Sankrail and the village Unsani under the district of Howrah by South Eastern Railway, a piece of land measuring more or less 151 acre, including the subject land, was published in the Calcutta Gazette notification being number Howrah number 13690 LA. I'm coming, just LA 22nd August 1961 under the Land Acquisition Act in relation to the acquisition entrusted to the state by notification number dated dato issued by Government of India. The Gazette notifications are available in the case. My lord, come to page 113, my lord.
Yes.
On the top, my lord, Tuesday, August 22nd, 1961. The lordship sees.
What are the plot numbers?
That's a plot number.
2195.
Yeah.
2195 and
2196.
RS. It is within the section 4. Notification is there.
And notification Howrah number 13690, my lord, first line. 22nd August 1961. And my lord, in the second column, my lord, kindly see survey plots in full.
Yes.
In full. These plot numbers in full.
Section 4 notification. Section 4.
Yes.
So, my lord, accordingly, land was acquired in the year 1961. My lord, thereafter, what happened? There is a transfer of land property from Eastern Rail to Southeastern Rail. There's a division, and from new division of Southeastern Rail comes. And thereafter, at that point of time, all the plots were not mutated, my lord, unfortunately. So, taking advantage of the situation, my lord, some land sharks, land grabbers, they grab the land, manipulate the documents, and then they misutilize the land properties. My lord, it comes into the notice of the Southeastern Railway from a public litigation, and the private respondent, Mr. Pratap Basu, also informed the rail, and we came into the knowledge. Thereafter, we informed the state authorities, kindly it was required, and kindly give us the possession, and recorded our name and mutated our name in the record of rights. And accordingly, my lord, Jila Parishad and other land authorities, they have recorded our name, muted our name after giving them the opportunity of hearing. All concerned, my lord. What happened, my lord? I think since there was an old record, taking advantage of old record, they sold, say, purchase, there was some partial purchase was taken place. But in the year 1961, since it was acquired, they cannot do that. My lord, thereafter, my lord, I will show 2-3 documents, my lord.
Compensation documents. That you paid compensation for the entire land.
Compensation was paid to the state government. It was state authority has
For the entire
paid
land.
for the entire land.
Because if you have not paid for the entire land, the acquisition lapses.
No, there is no allegation that it was not paid by the state authority or any authority.
The allegation is you have paid only for 2 decimals in the 2 plots.
That is the allegation. That is the allegation.
So please show me that you paid for the entire plot.
Yes, my lord. No, I'll show you 1 or 2 documents.
How can you file documents like this, sir? Where is your report? In the form of an affidavit?
No, I shall.
You cannot hand over documents like this to the court. Can
Very
you?
well, my lord. I don't want to do that. Very well, my lord. Very well, my lord. I don't.
Aware also.
No, I can definitely. I shall make over a copy.
They have to report it.
Very well, my lord. I don't want to work. My lord, I only want to show then the 2 documents. My lord.
यार ये चीज बहुत अच्छी लगी मैं तो हमेशा भूल रिमाइंड करती हूँ पापा भी फोटो ले लीजिए या इनकी लाइफ कोई दिक्कत थोड़ी
Page 164, 160.
164.
164.
हाँ आप ले दो
Page 164 is my lord.
भैया मेरे को फोन पे फोन किए जा रहे हैं कि
Land
तुम फंक्शन में
acquisition
नहीं आ रही हो
report of
क्या करें बताओ
special land acquisition.
यहाँ लगा हुआ नहीं है सामने
officer.
गेट
My lord, here, my lord, total area classifications of the shoot plot. These are 0.07 acres, Dover, and that of 9196, 0.05 acre, and Danga Musa. This is as per record of rights. It is found from the available office record that on receiving a proposal from Chief Engineer Construction, dated LA case number was initiated for construction of Maurigram, Dankuni link project. 3. Accordingly, both the plots were notified in full of the Land Acquisition Act within notification number 13690. Subsequently, declaration number of the said were published in the Calcutta Gazette, where shoot plots were included in the full area. My lord, now 5. On scrutiny of the office files, a draft statement of cancellation and a draft erratum to the declaration of number 17004 LA dated are found. My submission is, my lord, this draft. This is not finality. This draft, wherein it is seen that instead of being fully acquired, plots number Atuata Musa were partly acquired. This draft, my lord. And they are relying on the draft. Then come to next page, my lord.
Why don't you come to the next point number 6?
Possession was delivered to requiring body on 28/4/64, wherein 1 acre of plot number Atu and 1 acre of plot number Atu, along with many other plots of Muja. This all draft, my lord.
No, this is not draft.
As per
5 is draft.
he is telling, my lord, kindly come to next page.
Plot report. Yes.
My lord, come to next page, then you will understand, my lord. Come to next page. See,
Yes.
on the top, my lord, heading, this is draft erratum to declaration. So here, my lord, it was stated that there is a 0.1 decimal was to be acquired. Now, this draft, but not full. Subsequently, my lord, we got the letter. That is why I want to show you. I also give a copy to them that they informed us there was no resumption, there was no surrender of documents. The documents, my lord, land acquisition officer don't take it in record, but my lord, I want to bring into the notice of the Honorable Court on 12/8/22, land acquisition officer said that no relinquishment order proposal notification could be found in the corresponding LA record. My lord, this is my humble suggestion. There is no relinquishment.
But In that case, you must be having a document to show that you have paid compensation for the entire acquired land.
That will be shown by the State Department.
If that is not done,
That
then
is,
then the acquisition in respect of the remaining part lapses.
that I understand, my lord.
That's
That I
the law.
understand. Yes, I got down to you. That will be surely showed by the Jila Parishad and other state.
And I think it will be better if the state and the railways come with short reports in the form of affidavits.
Yes, my lord.
Because what you say need to be on record.
My lord, our report is very clear from page 164.
Only 1 and 1 decimals, 2 decimals have been acquired.
Other, nothing else is there, my lord. We have completely, my lord, yes, my lord, when your lordship was.
So if that is so, then your case doesn't stand at all, sir.
Then how they, my lord, I am humbly asking myself, how they mutated entire area of the plot in my name.
Does it confer right? Does mutation confer any right on you?
Record of rights.
Mutation altogether.
My lord, if there is record of rights in my name,
Does that confer title on you?
my lord, my humble understanding is, I may be wrong, my lord. It is my plot because they said that landowner is Bharat Sarkar, name of the father is Bharat Sarkar. Landowner is Dakshin Purbo Railway, Pita Bharat Sarkar.
Record of rights is not sufficient. There should be some document to substantiate the record of rights, isn't it? What are those documents?
Well, those documents are acquiring notification in the Gazette. And
Says that only 2 decimals have been acquired.
that is, my lord, again, my humble submission, my understanding and my instruction is to submit that. That is a draft proposal. That is not factified, my lord.
Acquiring body to answer. This is for the acquiring body to answer. First, there should be an acquisition.
Right.
For handing it over to the requiring body, right?
Right.
You are the requiring body.
Right.
See, if it has not been acquired at all, admittedly not acquired, how can the requiring body claim on that?
Not admittedly, my lord. Kindly.
The acquiring body admits.
That is, they are telling, let them file. I never find.
All to be taken by the requiring body.
Then let them file an
The
affidavit.
report is on record. Mr.
Yes, I find that
64. Yes.
No, my lord.
that evidence. Yes, I find that.
No, it is not here, my lord. In the
164.
164, my lord.
That is by the acquiring body.
That is
Special and acquisition officer.
that is on the basis of, my lord, they are telling there is a draft statement and draft erratum, and draft erratum is 165, my lord.
That is different. Point number 6 is different. 5
My lord.
is draft erratum.
My lord,
Point number 6 is possession.
my lord, I humbly submit point number 6 is possession, but my lord,
And point number 6 says that only 2 decimals were handed over to you.
Yes.
Nothing more.
very true, my lord.
You can claim only on those 2 decimals.
Very true, my lord. Then, my lord, give me an opportunity to file my affidavit so that I can disclose if I.
Come back with a report in the form of an affidavit. Affidavit is not required in this matter. The facts are very clear.
In my view, I have not any, I may not want to,
Let the
because
railways come
it's
back.
very clear. Previously, my lord, I filed that affidavit.
Let the railways come.
Yes,
So, my lord, according to record of rights, I am the landowner. They Jila Parishad given, and landowner is Pita is Bharat Sarkar. My lord,
Besides the record of rights, what document do you have?
no, that then
The court is not relying on the record of rights.
very well, my lord. Then, my lord, I have to take then.
You have to
Yes, sir.
substantiate the record.
Yes, my lord, I understand, my lord. Then I shall take the instruction and I shall come back. Sir.
Please do.
Grateful,
My
my
lord,
lord.
আমি কিছু
আজকে কিছু বলবেন?
হ্যাঁ বলবো। My lord, আমি পিটিশনার বলেছেন যে 2013 সালে আমি একটি জনস্বার্থ মামলা করেছিলাম চিফ জাস্টিসের ঘরে 28,142। পিটিশনার সম্ভবত মানে যেহেতু ওনার পিটিশনের মধ্যে এই অর্ডারটা দেননি 19/4/2022 তারিখে চিফ জাস্টিস টোটাল 352.26 একরের মধ্যে জমিতে টোটাল নো আনঅথরাইজড কনস্ট্রাকশন, নো ইলিগাল সেলিং, এটা অর্ডার করেছিলেন।
illegal selling, unauthorized construction.
একদম এবার
Legal selling বাধা নেই, authorized construction এ বাধা নেই, তাই তো?
কিন্তু 352.26 একরের মধ্যে এই দুটো প্লট রয়েছে।
হ্যাঁ, unauthorized construction এ বাধা ছিল, illegal selling এ restraint ছিল।
অলরেডি তো মিউটেশন হয়ে গেছে এবং বিক্রি পর্যন্ত হয়েছে প্রায় 1.5 কোটি টাকার কাছাকাছি, 4খানা ফ্ল্যাট বিক্রি হয়ে গেছে চিফ জাস্টিসের নির্দেশকে অমান্য করে। সমস্ত তথ্য আমার কাছে আছে এবং আমি আপনাকে জানাই যে অলরেডি আপনার কাছে, আমাদের কাছে তো এইরকম একটা কপি
গুলো ফাইল করতে চাইছেন?
হ্যাঁ,
ডকুমেন্ট গুলো আপনি একটু এফিডেভিট সহকারে ফাইল করতে চাইছেন?
একদম ডকুমেন্ট গুলো ফাইল করতে চাইছি।
Mr. Mukherjee, please come back, let them come back on affidavits.
So obviously, Lordship, in the mid, Lordship, kindly,
You
so
not
far
able to say.
Lordship, reply in respect of private respondent is concerned. Lordship, the writ petition which was filed in 2013.
If the private respondent wants to come back on affidavits, he has to be allowed, right?
Obviously, that is right.
So let them, even let the railways is also keen on affidavits, so let the matter be heard on affidavits.
Yes, but Lordship, in the meantime, Lordship, as the impugned order suggests.
Stayed, it will be stayed. Impugned order, prima facie, I do not know. Let me not make a comment on this today. Impugned order will be stayed.
My lord, আমি তো ডকুমেন্টস তো করবই, আমি আপনাকে আরেকটা কথা,
আপনাকে আমি এফিডেভিট দেওয়ার সুযোগ দিচ্ছি, আপনি ডকুমেন্ট গুলো একটা এফিডেভিট ফাইল করুন, তার সাথে ডকুমেন্ট গুলো অ্যানেক্স করুন।
দেব পুরনো খতিয়ান নাম্বার দিয়ে ফ্ল্যাট গুলো বিক্রি হয়েছে, যা
আপনাকে তো বলছে আপনাকে এফিডেভিট দেবেন,
ঠিক আছে।
তখন আপনি এফিডেভিটে সবটা বলুন, আপনার যা যা বক্তব্য এবং রেলেভেন্ট ডকুমেন্ট গুলো অ্যানেক্স করুন।
ঠিক আছে।
আমি এফিডেভিট দিয়েছি। Heard learned counsels for the parties. Paragraph, the order passed by the senior divisional engineer within bracket east, comma southeastern railways, comma Kharagpur on 31st January 2024. The date of the order, 31st January 2024, is assailed in the day. Paragraph. The primary bone of contention between the parties is that, according to the petitioners, comma, only 2 decimals of land in the plots in question, being plot numbers 2195 and 2196, were made over to the requiring body / the railways, and compensation paid for the same. Stop. The remaining portion of the plots were subsequently relinquished, and therefore no compensation paid to the owners, petitioners, owners for the same. Stop. Learned counsel for the state respondents also submits that only 2 decimals of the plots in question were made over to the requiring body, comma, that is, comma, the railways. Stop. Learned counsel for the railways submits that the entire plots were acquired by the state respondents and mutated in their name in the record of rights. Paragraph, learned counsel for private respondent number 14 speaks in tune with the submission made on behalf of the railways. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that the matter needs to be heard on affidavits. Paragraph, affidavits in opposition be filed within 2 weeks.
Little more time is required, my lord. I have to check so many documents, my lord.
4 weeks.
Long, 4 weeks.
4 weeks from date. Stop. Affidavit in reply, comma, if any, comma, be filed within a week thereafter. Within a week thereafter. Paragraph, let the matter go out of list for the time being. Stop. Liberty to mention. Paragraph, the order impugned, dated 31st January 2024, we state till 31st May 2024 or until further orders, comma, whichever is earlier.
Grateful.
In person. మహిళని కాసుకోవద్దా కానీ ప్రైవేట్ రిజిస్ట్రేషన్ సపోర్ట్స్ థ్యాంక్ యూ నెక్స్ట్
My lord.
Lord, item number 691 and 692 may be taken up together on the last occasion.
691 and 692.
Yes.
Well done. Yes.
My lord, on the last occasion,
Is
I had
withdraw ready with the instructions?
My lord, in this matter, my lord, I am ready with this instruction. My lord, first of all, my lord, this WP number 115, my lord. My lord, this is only but on the basis of assumption, my lord, they filed this petition.
yes, I had indicated that because other flat owners, 1118, Lordship, the second writ petition, Lordship,
The name of the building.
it is in name of two flat owners who reside in a same building, Lordship. The 1115 are also residents of the same building, Lordship. No notice.
No notice.
On apprehension.
My lord, on the basis of the apprehension.
I thought I was making my learned friends work easy by giving names, but I shall not.
Premature.
It might be, Lordship, because the other two.
Nothing can be done without service of a notice. That has not been
If
done.
Lordship records that, I am satisfied. My clients are satisfied because if
And my lord, in this matter, my lord, that is the WP number 1118. My lord, here, my lord, we served a notice, lordship, my lordship, kindly come to page 135 of this writ petition.
1118.
Yes.
Lordship, subject to lordship signed consideration, my lord, this writ petition is also a premature, my lord. In this matter, my lord, kindly see, therefore, lordship, the name has been given in this notice, and after the lordship, in terms of this notice, they totally complied with lordship, they served the objection. Lordship, they are after
The objection has not been disposed.
No, they are bound by the statute to dispose of my application.
Correct, sir. So, lordship, recent order yet to be passed, lordship. After this, lordship, recent order, their cause of action will arise.
It is a fact.
I absolutely appreciate what is coming from my learned friend, Lordship.
Apprehensive, I believe.
But there are apprehensions because Lordship already knows on the last occasion, I had indicated that Mr. Oyon Banerjee is moving a writ petition on a similar point when the notice was served upon a building.
That's a different issue.
But here, Lordship, two persons,
The notice has been challenged.
two persons.
From that
No,
report.
I am not on here. I do not challenge the notice. I say in 1118, I say that the notice was served. And Lordship, I have filed my written objection against the same. That has no.
Let that be considered.
That may be considered. And Lordship, with regard to the first writ petition that my learned friend says it is premature, if she says that I shall be served with a notice and then appropriate proceeding.
Eviction without a 26-2 notice.
My lord.
Lordship, the apprehension is
So
there.
you say it can be.
Should not be. I say that apprehension is there.
Will you withdraw the first matter?
First matter withdraw.
Because there is no question of a liberty also because
Yes.
my lord, it will be a different cause of action altogether.
My lord, the apprehension, I am told that people have come there with the intention of demolishing the property. That is why, Lordship, these writ petitions.
Without a 26-2 notice.
That is what I say this on instruction.
First matter is not matter.
I say this on instruction, Lordship.
Conceivable. I mean, how? I have to reject it as premature. Instead of
First-
that, I
first,
think
Lordship,
it will be
then I-
better for you if you choose not
Lordship,
to
I
proceed with it.
My lord. And lordship, in the case of the second case, lordship,
Let the
recent
objection
order
be
is
disposed of.
my lord.
Let the objection be disposed of.
Yes,
within a
Yes.
certain
Recent order.
Lordship, in the meantime, if they do not take any coercive steps, I absolutely bow down before your Lordship to that.
The recent order, lordship, until and unless lordship, we pass the recent order, lordship, after the
Yes,
lordship,
but
they are.
please do not. I'll record that no coercive steps will
I
be
am
taken
very grateful.
before the objection
My
is
lord, this is
disposed of.
the lordship kindly dispose of this lordship in accordance with law.
Dispose of.
Yes,
Yes.
lord, in accordance
There
with
will,
law.
there will be an additional line.
I am very grateful.
Lordship, in this case, the notice has been there, Lordship, until and unless reasoned order has been got,
Notice
no
does
action
not
has
give
been
them the right to just come and demolish my property.
Lordship,
It does not give them the right. They have to adhere to the principles of natural justice.
People are already approaching the.
Lordship, totally, Lordship, on the basis of the apprehension, Lordship, just.
No,
Lordship, I should
two
say-
other persons who have approached, they were
appreciate,
served
Lordship,
with the
these-
notice.
Lordship, these two petitions also, Lordship, kindly, Lordship, allow me, Lordship, 1 minute, Lordship, in these two cases also, Lordship, one, Lordship, the Belgudi Expressway is involved, Lordship. Same, Lordship, we are also facing a contempt in the same
So
project,
what
Lordship.
can this court
Lordship,
do?
Sorry, so
That is immaterial.
Lordship, my point is, the notice has been there.
To law.
No, Lordship, at this moment, Lordship, the law has not been totally, Lordship, ignored. At the very
Not
instant,
totally ignored. It is ignored to some extent.
Lordship, on what basis, Lordship, kindly give them, Lordship, any example?
The people are coming to demolish.
Lordship, kindly show them any document.
How can you show people demolishing?
Lordship, without any document, Lordship, without any notice.
You demolish with documents.
Without any notice, my lord. As per the section 26.
111115 order করুন যেটা 691. The petitioner seeks to withdraw the it is submitted on behalf of the petitioner that the petitioner does not intend to proceed with the matter any further. Paragraph in view of the above, the petition being WPA such and such is dismissed for non-prosecution. There shall have been no arrest costs or is certified with 111118 692. 692 heard learned counsels for the parties. The petitioners have assailed the
At 135, Lordship. 135 and 136, two notices.
notices issued by the authority under section 26 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act, 2002. The petitioners have submitted an objection to the said notices, which are yet to be considered. Stop. The petitioners submit that no coercive steps be taken against them in respect of the building in question. It's a building, isn't it?
In the building.
Building in question prior to consideration of their objection by the authority. Paragraph learned counsel for the NHAI submits that shall I record that you will not take coercive steps before the objection
Well,
is
not if you follow Lordship, that situation is Lordship on the basis of the apprehension and every time Lordship the
So
petitioner
I'll
asks
record you. I don't think you need to add anything, Mr. Modi.
Well, only one thing, Malad, it is in the statute there, Lordship, until and unless you pass the recent order, Lordship, no action has been taken, Lordship. This is in the statute, Lordship. So without Lordship, we cannot go beyond the statute, my Lord. Lordship, after that, Lordship,
It's very unfortunate that this doesn't always happen. The authority often goes beyond the statute. isn't it?
Lordship, in this case, Lordship, as per after once, Lordship, we issued a 26 to notice, Lordship. Nowhere, Lordship, we demolished any document, eviction, unauthorized occupation is even happened, Lordship, without any passing any recent order.
Upon consideration, upon consideration of the submission made on behalf of the party, I'm not recording your submission. Parties, this court is inclined to hold that since the petitioners have filed an objection against the notice issued against them by the
The
authority.
two separate notices were issued, two separate objections were filed.
The petitioners have filed objections against notices issued against them by the authority, the concerned authority being the respondent number, who will dispose of
Respondent number 2, subject to what my learned friend says.
the project director. Should be. The second respondent be directed to second respondent consider and dispose of the objections within 2 weeks.
My Lord.
Yes, within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law. Paragraph pending disposal of the objections, no coercive steps be taken against the
Very
petitioners
grateful.
by the authority in respect of the building in question.
My lord, only one
Suppose
point
so.
should be recorded, Lordship. This writ petition is premature on, if your Lordship can record it on my part, Lordship, because Lordship, their cause of action will arise after the recent order will pass, Lordship.
The learned counsel for the NHA submits that the writ petition is premature since the cause of action of the petitioners shall arise only upon disposal of the objection filed by them.
Since it is in the Lordship, in the statute is there, Lordship, they can prefer an appeal before the civil court.
Difficulties, Ms. Roy, there are a lot of things in the statute.
No, my Lordship, on the basis of the assumption, every time, Lordship, they come, and Lordship, because there is a question of any public.
Very grateful. I am very grateful. Matter is minor. Today it will not be taken up. Can you take it up tomorrow at the item number 1?
দিদি লিস্টটা কন্টিনিউ করবেন কালকে মেনশন ম্যাটারে মানে এখন যেটা বললো না 693 টাকে করতে হবে মানে এখান থেকে কন্টিনিউ করবেন
God bless you. I'm very grateful.
কোনটা কন্টিনিউ
Original site, division bench, new applications, item number 1.
Recall, Malad, this is Malad, that vacating application, Malad, issue number 3 of 2023, which we have filed.
Are all the parties present? The respondents?
Yes, Malad, the respondent, we
Malad,
have
I am
got
appearing to
a
Bharat
affidavit,
Hotels,
Malad, which has
Malad.
been filed by them. And Malad, there is some.
Right, yes.
I'm online.
Malad, Malad, our affidavit in reply, Malad, all that Malad is done. Malad, I'll tell Malad quickly, Malad, what the matter is.
What is this that you're filing? It's scary.
Malad, Malad, at least for the present, Malad, that don't need to look into that. Not immediately, Malad.
Yes.
When Malad, this comes from the bench, Malad, we don't know also how to react. Whether I should say it's not significant or whether I should say, Malad, it's significant. Malad, Malad will recall, Malad, this is Malad, a company in liquidation. Malad, the company, Malad, was directed to be wound up, Malad, by this Honorable Court by an order of 31st January 2013. Malad, it went up to the division bench, and Malad, that was affirmed, Malad, on 2nd May 2013. This is Malad, Dunlop, India. Malad, Malad, Dunlop had Malad, lot of Malad, this to manufacture Malad, tires and all that. Malad, we, Malad, ICICI Bank, Malad, had got Malad, a property from an associate company of Dunlop, which, according to us, Malad, the property belonged to that company. And Malad, we had Malad, taken it, Malad, that was Malad, a security for a substantial loan, Malad, which was given. Malad, we proceeded against that property with regard to Malad, taking whatever steps Malad, are required to be taken, Malad, under surface, Malad, that steps Malad, we took. Malad, some of the creditors of Dunlop came, Malad, and made an application saying that this property could not have been transferred from Dunlop to Malad, this other company. To Malad, Bhartiya and Malad, to other companies. That's Malad, what happened. Why Malad, we are Malad, embroiled in this. In that connection, Malad, an order was passed, and Malad, there's a disclaimer application which is pending, Malad, which, or rather, Malad, not a disclaimer, a fraudulent preference saying that no, it could not have been transferred. That's the issue. And Malad, in that context, Malad, an order was passed saying that don't deal with the property anymore. Or Malad, there should be property should be with us, really, Malad, because we have Malad, this property, Malad, because Malad, it's a claim which we have against Malad, the property as Malad, a security. We had Malad advertised it several times. Then Malad, it had to be sold. And Malad, under the surface, Malad, we are also entitled to Malad to take Malad, participate in the sale, Malad, and buy that property, which is what we have done. Now, Malad, when we hold a property in law, we can only hold it for a certain number of years. And then, Malad, every year you have to apply, Malad, to the Reserve Bank of India to get permission, Malad, to keep on holding it. They may or may not, Malad, give permission. Malad, the interim order which was passed, and Malad, another very important thing, which is why, Malad, we have come back. The Honorable Supreme Court, while dealing with the matter, initially, Malad, had also, Malad, said that property not to be dealt with. Then, Malad, Supreme Court said, no, you secure this amount and then you can deal with it. Thereafter, Malad, we dealt with it. And then, Malad, that security was also, Malad, vacated by the Supreme Court. So the property, Malad, now, Malad, has been dealt with in that sense. Malad, though, Malad, sale has been to me, but it has been dealt with. Now, why, Malad, we want, Malad, this order? Because this order, Malad, was passed on 29th January 2019. Now, Malad, already, Malad, we are, Malad, practically, Malad, 5 years, Malad, down the line. Now, I want vacating of this order because it's passed by a division bench. So, Malad, till, Malad, the matter is heard out, Malad, before the first court, is, Malad, pending there, Malad, for quite some time. Till the matter is heard out, I want vacating, Malad, the simple reason is, Malad, if the order is vacated, it's really, Malad, a risk which I run.
And the interim order is still disposal of the...
Yes, that's why, Malad, I want vacating. I have to come here. Malad, the vacating of the interim order only means that, Malad, the property now becomes, Malad, at my risk. Because if they were to succeed to say that, no, the property doesn't belong to, Malad, the other companies which have, Malad, given this, Malad, as valuable security to me for a substantial loan, Malad, which was obtained, then, Malad, it could not have been secured. Then, Malad, different consequences follow. But, Malad, there's no justification or reason as to why, Malad, the property which was secured to me should, Malad, have a fetter from being dealt with. This is, Malad, really the issue. That is why, Malad, this, Malad, kindly, Malad, I want to show, Malad, there's a list of dates, Malad, why I'm saying, Malad, just to, Malad, give a little background, Malad, of the matter. If, Malad, kindly comes to, Malad, page 29, Annexure B. That is why, Malad, today, Malad, the property being dealt with or not being dealt with by me, because I'm also, Malad, under statutory obligation, Malad, to deal with that Because my lord, they have also challenged the sale and my lord, the transfer. Now we have my lord, in the trial court, or rather my lord, in the company court now, we have taken this point that if I proceeded under the Securitization Act, then the company court doesn't have jurisdiction. And my lord, there are judgments to that effect saying that company court doesn't have jurisdiction. It's a overriding, because it's a special law. It's a overriding provision of the SURFACE, which my lord, will prevail over Companies Act. So in any event, company court doesn't have jurisdiction. That issue, my lord, whether my lord, I could have dealt with the property or not, that has to be, my lord, decided, my lord, by the, really, my lord, if I say the SURFACE court. So that is why, my lord, now, my lord, we made this application. Well, first day, my lord asked me, why shouldn't you go back? Well, that's correct. Normally, my lord, we would have gone back. But here, my lord, because it's a division bench order, and my lord, from 2019, my lord, it's been continuing. That's more reason, my lord, I'm saying that kindly vacate it. After that, my lord, wherever, whatever is decided.
Expeditious disposal of the matter with the company?
No, my lord, I want, my lord, vacating of the order. My lord, the matter is going on there.
Because that will solve the issue once and for all, isn't it?
My lord, it's not a question, my lord, with the greatest respect, my lord. It will take its own course. Because, my lord, there are several creditors have come. Now, my lord, has seen here also, my lord, this other interveners who have come, who really, my lord, shareholders of, my lord, their associate companies, my lord, have done up. But naturally, my lord, they want to stall
Absolutely.
my dealing with it so that, my lord, the property somehow, my lord, stays there. But this is not Dunlop's property. My lord, this is not the property of the company in liquidation at all. It is a property belonging to, my lord, another company which has connections with Dunlop. So, title, my lord, is...
Transaction is also under challenge, isn't it?
No, my lord, the transfer of the, my lord, the transfer, yes. But I'm saying, my lord, if that is, they are successful, then, my lord, in any event, my lord, I will not be able to deal with the problem. So, my lord, property coming to me now, my lord, is really, doesn't, my lord, fetter, my lord, the hearing of the matter.
How to really jeopardize?
Because, my lord, I can't deal with the property. I have, my lord, the loan was, my lord, a substantial amount. That's, my lord, my security. So, kindly see, my lord, though, my lord, I have adjusted the loan, I am, my lord, given credit for the loan, I have the property, but I can't deal with it. That's, my lord, my difficulty. My lord, kindly, my lord. And, my lord, this is, my lord, a property, but it's a very valuable property, my lord, in Bombay. And, my lord, we are spending, we have said so, my lord, why we have asked. We are spending, my lord, nearly, my lord, 4 crores, my lord, every, my lord, year. Until now, my lord, about 75.63 crores, my lord, we have incurred, my lord, maintaining this property. Kindly, my lord, come to page 29, my lord, of this application. ACO 3. Just a little.
ACO 3, right?
ACO 3.
Page 29.
29, my lord. Just, my lord, a list of dates, my lord. I also want to show, my lord, what has happened, my lord, in the course of, my lord, these proceedings.
Yes.
Whenever you're ready. My lord, my leaders here, my lord, I was trying to, my lord, urge him, my lord, to.
I had an appointment justice, so I got held up.
Perfect.
That is why.
My lord, I'll finish, my lord, this, my lord, aspect, and, my lord, then, my lord, seek permission, my lord, from Mr. Mitra to, my lord, address. My lord, just, my lord, to show the, kindly see, my lord, 17 August 63, 64. My lord, these are the page 29. Just to, my lord, certain properties, my lord, were acquired. Then, my lord, this is all, my lord, background history, my lord, with regard to how Dunlop, my lord, is getting. Show item 17. Item 17, which shows the transfer. Where's the Wally property transfer? My lord, kindly see, my lord, entry 17 at page 34. My lord, this is no. My lord, 17 is one of the properties.
We are only concerned with Wally property.
So
This is Chennai property.
this is Chennai property. That is, my lord, not the subject matter here, but that is, my lord, also, my lord, something, my lord, which was also mortgaged. Then kindly see, my lord, item 20.
Yes.
3rd January 2008, DIL, my lord, is Dunlop India Limited executed a deed of assignment dated January 3, 2008 for transfer of the leasehold rights in the Mumbai property to my lord, BHL, my lord, is Bhartiya Hotels Limited. Then, my lord, kindly come to page 38, my lord, how, my lord, we came into, my lord, the transaction 22.
Yes.
In the year 2008, Wealth PT Limited approached ICICI Bank Limited, Singapore, offshore branch for availing a credit facility up to an overall limit not exceeding $125.0 million. Since the offered security, especially landed security situated in India, offshore branch indicated to Wealth PT Limited, it will also require a guarantee from Indian Bank. Consequently, the parent company of Wealth Limited, namely Shalini Properties and Developers Private Limited and SPI Resorts Limited, owning 45% and 43% respectively outstanding share capital, approached, I come in, ICICI Bank Limited, India, for issuance of a standby letter of credit, securing the entire amount of facility proposed to be availed of by Wealth PT Limited from the said offshore branch. Two properties, Mumbai property belonging to BHL, and 58 acres of land of Chennai property belonging to DPBL were mortgaged with ICICI India to secure the standing bank letter of credit, standby letter of credit. Then the said two companies also stood as corporate guarantee respect to said facility. These two companies also subsidiaries group companies of DIL. So that is how the connection comes in. So Dunlop in 2008 had transferred this property to one of his subsidiaries, Bharatiya Hotel Limited. When I came into the transaction, then they said they offered this for security.
Yes.
Then note 1, EIL through Shalini Properties and Developers Private Limited and SPI Resorts Limited owns Wealthy Singapore. As such, no fault can be found with other group companies on DIL providing securities for the said loan. Said loan was taken for repayment of existing debts, and thus the creditors in the hands of Wealthy Singapore changed from certain other groups companies of DIL to ICICI Singapore. Then 30th June, V-Day to credit arrangement letters, ICICI Bank sanctioned the credit facility to $125 million US. Then 30th June, yes. Kindly permit Mr. Mitra is
I shall just give your lordship a very short background. This list of dates is very complicated. Your lordship has been pleased to see everything and complicated. So I just will give your lordship the if I may just indicate to your lordship, my lord, we are concerned with the Bombay property situate at Worldly. This is a very valuable property. Dunlop became, my lord, the leaseholder of this property in perpetuity, and that was in the year 1968. And since then, my lord, Dunlop had been holding this property as a leaseholder. Now, my lord, this particular property, Dunlop wanted to transfer at a point of time when it was passing through difficulties. And my lord, this Worldly property was transferred to Bhartiya Hotels Limited. Now, Bhartiya Hotels Limited could not pay the entire amount of money at that time for the purpose of getting this property. So the shares were allotted. Shares were allotted in Bhartiya, and my lord, Bhartiya became the owner of this, in the sense, assignee of this property, assignee of the leasehold interest, Bhartiya became. And after that, my lord, after the assignment had taken place, well, the necessary changes took place insofar as the the records of the company is concerned. In the balance sheet, in the accounts, it was shown that this particular property has gone to Bhartiya, and well, the money has come. This was with regard to this Dunlop. Now, well, this have been all been set out here. I do not want to unnecessarily at the moment complicate the issues by taking your lordship through that. Now, my lord, on 28 February 2007, the physical possession of this property was made over to Bhartiya. So it was handed over. Now, how ICICI Bank came into the picture? ICICI Bank, my lord, was approached for, my lord, a loan, an amount of loan to, my lord, a Singapore company who had, my lord, my lord, some interest in this. So what happened was this, that in one way, my lord, that's been said here. If your lordship kindly comes to page 38, this is the way. I am not going to trouble your lordship. This particular property was mortgaged with ICICI Bank, and ICICI Bank, my lord, advanced a sum of US dollars 125 million against this property. So ICICI has got an interest was created in ICICI in the year 2008 in respect of this property by way of a mortgage. And my lord, as a mortgagee, my lord, the ICICI Bank became interested. In the meantime, my lord, a lot of things happened insofar as the company is concerned. Application was made for winding up of the company. This was sustained, company meaning thereby Dunlop. That particular order of winding up by the trial court, that was challenged in the appeal court. Appeal court dismissed that, my lord, the appeal. Thereafter, the matter went to the Supreme Court. Now, when the matter went to the Supreme Court, I'm just giving your lordship the very short, with the background. When the matter went to the Supreme Court, this is one of the properties the contributories and the creditors went after. They said that this particular property belonged to Dunlop, and therefore you cannot just, so to say, wish it away, just like that in the ICI. So ICICI stepped into the picture, made an application for intervention in the Supreme Court in respect of this property. I am not talking about the Amadur property. Both properties were involved, but since I am concerned today in this application with regard to Bombay property, I am confining myself to that. So they made an application before the Supreme Court saying that this is the property which has been mortgaged to me, and therefore you give protection to this property. Supreme Court at that stage was pleased to pass an order of injunction. Do not deal with the property until the matter has been sorted out in the trial court. If you have got any grievance with regard to this, the transfer of this property by way of fraudulent preference, you do whatever you want to do before that court. In the meantime, you stay your hands. When this was the situation, and this is, my lord, where I wanted to draw your lordship's attention, after some time, ICICI Bank made an application before the Supreme Court saying that you have stayed my hands, but this particular property is a valuable asset so far as I am concerned, and this is my security. If it is wasted in the meantime, by reason of the fact that a stay order is continuing for years together, then my security will be jeopardized. So please do something about it. So, my lord, there, I take your lordship to that. Supreme Court, kindly, my lord, come to 8th May 2015. I am skipping all this. Kindly come to 2015, page 67. No, 2067. No, 67. No, that page 64. 64. Kindly come to page 64. 54. 2058 May 2015. Page 54. Kindly, may not come to page 54.
Yes.
My lord, kindly come to 61, item number 61 first. On 22nd April 2015, Kanpur Properties and Finance Private Limited filed an application for direction being IA number 37 of 2013 in SLP Civil, seeking directions and an injunction against ICICI Bank from going ahead with the auction of the Mumbai property in terms of the auction notice dated 10th April 2015. In fact, my lord, on 10th April 2015, that is item number 60, the first time we issued a notice, my lord, for auction. My lord, kindly come to before that. Yes, my lord, kindly come to before that page, item 50. No, actually, No, before that. Just give me 1 second. My lord, kindly give me, I shall give you, lordship, exactly there are so many dates. I will request your lordship to, my lord, come to first, yes, 58, your lordship has seen. First is 57, 14 February 2015. Trusteeship so-and-so, on behalf of ICICI Bank, published notices in 4 different newspapers, including publication of vernacular language on 14 February 2015, providing public notice that possession of the Mumbai property has been taken by 3i Infotech Trusteeship Services Limited on behalf of ICICI Bank on February 10, 2015. Then, my lord, 58, on 25th February, Kanpur Properties made an application before the Supreme Court seeking direction against ICICI Bank from going ahead with the auction. Now, my lord, then, my lord, kindly come to the next date, my lord. On the, I've shown your lordship the 25th February, then kindly, my lord, come to 59. Infotech Trusteeship Services Limited issued public notice for tender come auction for sale of secured assets being Dunlop House situated at Worli, etc. And, my lord, kindly see the auction notices were published in Economic Times, Telegraph, Economic Times in Mumbai, Telegraph in Kolkata, vernacular language in Pudhari in Mumbai, and also Anandabajar Putrika in Kolkata. No bids were received by the 3i Infotech, that means ICICI. Then, my lord, Infotech Limited issued another tender come auction notice. Since, my lord, it was not obtained, another notice. My lord, that also was not successful. My lord, the same was also informed to the official liquidator. Official liquidator also was kept in the loop. Then Kanpur Properties, my lord, 22nd April 2015. This is important. Kanpur Properties and Finance Private Limited made another application for a direction that the injunction restraining ICICI Bank from going ahead in the auction in Mumbai property in terms of auction notice dated 10th April. And in that aforesaid application filed by Kanpur Properties, specially petition so-and-so, Supreme Court was pleased to direct, let these matters come on 14/7/2015. Till then, the property shall maintain status quo as it exists today. That particular interim order was extended subsequently, and, my lord, till the next date of hearing, that is the next date, 14 July, the Supreme Court was pleased to direct to continue the earlier order directing status quo till the next date of hearing, that is 5th August 2015. And further directed the main SLP will come up for hearing on the next day. Then 5th August 2015, the main SLP was directed to be listed in the first week of October 2015. And this status quo order, which was there, my lord, that expired on the 5th of August. No status quo order remained. My lord, thereafter, on 4th April 2016, 3i Infotech, acting as security trustee for ICICI Bank, took symbolic possession of Chennai property. I am not troubling your lordship with Ambattur. This is the 4th April. Kindly come to 13th April, which is important, 69. 3i Infotech issued another tender come auction notice for sale of the Mumbai property. Again, my lord, the publication in newspaper. And only one bid was received, and that was a conditional bid. So therefore, that was not accepted. Then, my lord, on 21st May, the 4th tender come auction notice was issued. I'm showing this to your lordship for the purpose of impressing upon your lordship that attempts were made to sell the property by public auction. And, my lord, the Supreme Court knew about it. Again, my lord, the advertisements, I am not troubling your lordship. Then, my lord, 66. It ceased to operate. I have told my lord that it ceased to operate on 5th of August. And we made an application by way of abandoned caution for vacation and or modification of the orders dated 8th May 2015 and July 14, 2015, two status quo orders. Then, my lord, on 12 February 2016, when the aforesaid IA 3940 filed by ICI were listed on 12 February, the Supreme Court, upon consideration of the facts, was pleased to pass an order vacating its earlier order dated 8 May 2018 and 14 July 2015 should be, and 14 July 2015, and further permitted ICICI Bank, my lord, this is very important. I want to show this my lord, document to your lordship. To, my lord, subject to furnishing a bank guarantee of rupees 520 crores. This is on the 12th of February 2016. My lord, page 72, my lord, kindly come in this connection. I thought that this order should be shown to your lordship, Supreme Court order. Page 72, this is the order dated 12th February 2016. At page 73. The interim orders of this court, dated 8 May and 14 July 2015, passed in so and so, are vacated. Kindly note this.
This is the presence of all the
Yes.
Everyone
And my lord, kindly see the parties. Everybody was present. In their presence, this happened. And my lord, what was the condition? Subject to furnishing of a bank guarantee of rupees 520 crores. In the event the auction fetches any amount in excess of ICICI Bank will be liable to furnish bank guarantee for such excess amount also. So, in pursuance of this order, ICICI Bank furnished bank guarantee of rupees 520 crores. So, my lord, the embargo, the impediment which was there before the ICICI Bank to putting it up for sale, my lord, that was removed. In other words, Supreme Court said, you furnish this bank guarantee, sell the property. If you find something more, then that additional amount will be deposited also. Fair enough. And we were satisfied with this order. We went ahead. And this order was passed in the presence of all the parties. Then, my lord, on 22nd February, after furnishing the requisite bank guarantee on behalf of the bank, the third auction notice was issued. I've shown to your lordship. Your lordship kindly comes back to the to the list of dates at page 56. 22nd February, pursuant to the order dated 12 February 2016 of the Supreme Court on February so and so, issued another tender cum auction notice. Again, my lord, publication in all these newspapers, Economic Times, Telegraph, Anandabajar Potrika, and all that. Now, my lord, then what happened was, again, my lord, the fourth notice was issued on 13th April, because, my lord, all the time we had been trying to get this particular property sold so that, my lord, we could recover the amount of money. And, my lord, ultimately what happened was this: no bid was obtained in respect of this property. There was not one bidder available pursuant to all this. So, my lord, what ICICI did was, ICICI purchased this property. My lord, this is on, your lordship will be pleased to come to that particular list. Yes. Kindly come to 71. This is on 21st June 2016. 21st June 2016. Page 58. In view of no other bid being received, bid was made by ICICI Bank, being the secured creditor, for purchase of the Mumbai property. Bid of rupees 200 crores. Bid of rupees 200 crores was made by ICICI Bank, and EMD of rupees 5 crores was submitted. Then 3i Infotech issued letter to ICICI Bank for confirmation of this bid, which was confirmed by ICICI Bank. Then 22nd June, 3i Infotech issued a letter to ICICI Bank confirming the bid and requested the balance consideration for sale. ICICI Bank furnished consideration by way of demand draft of rupees 193 crores. Then confirmation of the receipt of the balance consideration by 3i Infotech and furnishing self-certificate and possession take over receipt to ICICI Bank. Then, my lord, on 29 July, SLP came up for hearing, and the Supreme Court was pleased to dismiss the same along with all pending applications. Well, this is the appeal against the winding up order. That came up for final hearing, and my lord, the Supreme Court was pleased to dismiss that on the ground of non-compliance with the order of the Supreme Court. As observed in our earlier order date 25th July, the present special petitions are also pending application therein shall stand closed. My lord, thereafter, this is another important date. On the 9th of September, Lordship will be pleased to come to the next date, 9th September 2016. This is, my lord, page 74. I will not take your Lordship the list of dates. Kindly come to page 74. On 9th September, this matter came up before the Supreme Court with regard to our sale of this property. And kindly see, my lord, the Supreme Court order at page 74. 9th September 2016. We have perused the office note. What happened was this. Well, after this property was sold, I tell you, Lordship, what happened. After this property was sold at 200 crores of rupees in favor of ICICI Bank. So far as the registry is concerned, Supreme Court registry, they were holding 520 crores in their hand. So Supreme Court registry sent an office note to the Chief Justice saying that what should we do with this money? On that manner, this order was passed at page 75. Kindly see that. We have perused the office note. The bank guarantee of rupees 520 crores furnished by ICICI Bank be returned to the said ICICI Bank. If the property has been sold in the meantime, the proceeds thereof be dealt with in accordance with law. The official liquidator will take necessary steps. Any of the contesting parties will be at liberty to approach the official liquidator in this regard. So, my lord, the Supreme Court took note of the fact that the property has been sold. So, my lord, on the sale, the blessing of the Supreme Court was obtained. And, my lord, the bank guarantee which was furnished, the Supreme Court directed to return the bank guarantee. But insofar as the sale proceeds is concerned, you hold it subject to further orders of this court. So, as at present, my lord, the situation is this. This particular property has been sold to ICICI. ICICI has become the owner of the leasehold right and in respect of this particular property. And, my lord, since after, my lord, becoming the owner of this property, the ICICI has taken possession. But the problem today is this, that this matter is pending over a long period. And this property is being held by ICICI Bank all this year. First of all, the property is deteriorating. Secondly, my lord, for this property, it's a huge property. The amount of taxes which are required to be paid is also very huge. So for maintenance, for my lord, the payment of taxes and all that, my lord, a huge amount of money is being spent. But, my lord, in view of the order of the court, in particular order of the division bench, to which, my lord, your lordship was a party, there is an order of injunction restraining the parties from dealing with any of the property. So I am holding on to the property. I can't do anything about it. Today I have come before your lordship with this application for the purpose of lifting this interim order, for the purpose of, my lord, dealing with this property, because otherwise, if I may now, at this juncture, show your lordship the reason why I have come before your lordship. Kindly, my lord, take the petition. Para 13, page 7. I've given your lordship the complete background as to what happened. Now, my lord, para 13. The appeal emanated from Smith's application, pursuant to which interim order dated 10th October 2018 and the order dated January 29, 2019 were passed. And in terms whereof, the applicant had been restrained from dealing with the worldly property without leave of this honorable court. The subsistence of the said order has caused grave harm and prejudice to the applicant, including loss of public money to the tune of several crores, and hence the present application in the circumstances which are enumerated hereinafter. Para 14. The applicant states and submits it has made multiple efforts to expedite the hearing of the OL application and the Smith's application, but to no avail. The matter has been mentioned on several occasions before the Honorable Court, taking up such applications, most recently on March 30, 2023, highlighting the urgency involved in the matter, but the said application could not be taken up for hearing. The last order with regard to this application dated 21st April 2023 was passed by the Honorable Court is annexed herewith and marked with the letter F. Well, let kindly come to page 98. This is the order. This is my lord. On 21st April 2023, this order was passed. Learned counsel appearing for the official liquidator is not ready. List this matter on 28th April. Then, my lord, we have kindly come back to page 7 again. Despite being the rightful owner of the worldly property, the applicant continues to incur costs to maintain the same without being able to benefit from it, and which has led to the current situation becoming completely unsustainable. In terms of Section 9 of the Banking Regulation Act 1949, I shall show to your lordship this. The applicant is required to dispose of any immovable property held by it, except as is required for its own use, within a period of 7 years from the acquisition of the same, extendable up to 5 years on consideration by the Reserve Bank of India. My lord, kindly take the Reserve Bank of India, this Banking Regulation Act, Section 9, I shall just hand up to your lordship. Kindly take, my lord, Section 9. The title is Disposal of Non-Banking Assets. Said, notwithstanding anything contained in Section 6, no banking company, we are a banking company, shall hold any immovable property, howsoever acquired, except such as is required for its own use, for any period exceeding 7 years from the acquisition thereof, or from the commencement of this act, whichever is later, or any extension of such period as in this section provided, and such property shall be disposed of within such period or extended period as the case may be, provided that the banking company may, within a period of 7 years, as aforesaid, deal or trade in any such property for the purpose of facilitating the disposal thereof. Provided further that the Reserve Bank may, in any particular case, extend the aforesaid period of 7 years by such period not exceeding 5 years, where it is satisfied that such extension would be in the interest of the depositors of the banking company. So, my lord, 7 years plus 5 years, all told 12 years, my lord, a banking company can hold an immovable property. And that also with the permission of the Reserve Bank of India. My lord, now, if your lordship, my lord, takes the date, this particular property was acquired, as I told your lordship, by ICICI Bank on 27th October 2016. This, your lordship, will be pleased to find page 59. Page 59, I have shown to your lordship, page 59, the list of dates. So 29th October 2016, কতদিন হয় 7 বছর কবে এক্সপায়ার হচ্ছে 23rd well the period of 7 years expired.
Still have about 3 years to go. 7 years and 5 years.
75 years, my lord, of course, that 5 years has not been granted by Reserve Bank of India. Only 1 year has been extension has been granted. So 5 years, 7 years expired in 2023. And my lord, 1 year extension has been granted up to 2024 by the Reserve Bank of India. Of course, if Reserve Bank of India wanted to give me extension for 4 more years, perhaps 4 more years. But my lord,
one thing, Mr. Mitro,
yes,
it's just
yes, lordship.
Will this property be covered by this provision because there's an order of the court?
It should be covered because, my lord, this is an acquisition.
How can the RBI's direction supersede the court order?
No, it is not really court order in that sense of the term. The court has, my lord, only restraint dealing with the property because my lord, the litigation is
That
pending.
includes.
Yes,
disposing
yes,
of
of
gold.
course, of course. If the court order remains, I cannot do anything about it, notwithstanding Reserve Bank of India intervention. Absolutely, your lordship is perfectly right. But my lord, that is why I am coming up before lordship. This is one of the reasons which has been put forward. That this is the reason. This is one of the reasons that there is some statutory embargo. By reason of the court order, I am being unable to deal with this property. The statutory embargo is, my lord, 7 years and 5 years. So I am drawing attention of the court that kindly expedite the matter so that, my lord, this particular embargo is lifted from me. And if this embargo is lifted, then I, my lord, comply with the statutory provision. Let me put it this way. But I cannot say that once the court order intervenes, my lord, that anybody else can do anything about it. Well, this has been put forward as one of the reasons as to why this, that is paragraph 15. Kindly, my lord, come to paragraph 15 once. In terms of Section 9 of the Banking Regulation Act, the applicant is required to dispose of any immovable property held by it except as required for its own use within a period of 7 years from acquisition of the same, extendable up to 5 years on consideration of the Reserve Bank of India. The said order has prevented the applicant from taking any meaningful steps regarding the said property since January 2019. And the applicant is obliged to approach the RBI from time to time to seek an extension of this period with proper explanation. But the explanation is, of course, the court order is a good explanation. This honorable court would be pleased to appreciate that more than half of the maximum extendable statutory holding period for such asset has already expired, during which time the applicant has been deterred from exercising its ownership rights in the worldly property. This honorable court would also, in view of the same, appreciate that the time remaining with the applicant bank for exercising its ownership rights over worldly property is grossly inadequate, and therefore there is an immediate need for vacation, alteration, modification of the said order. Then, my lord, para 16. The applicant further states and submits that it has been regularly paying large amounts of property taxes on the worldly property without being able to utilize or monetize the said property. The last demand raised by Brihanmumbai Nagarpalika, by its letter dated December 26, 2022, assessed the outstanding amounts in relation to the worldly property to an amount of rupees 84 lakhs approximately for the period between 1st April 2022 and March 31, 2023. And an outstanding amount of rupees 52.13 lakhs approximately was directed to be paid. The applicant made payment of such amount of rupees 52.13 lakhs under protest, under covering letter dated so and so to Brihanmumbai Nagarpalika. In total, the applicant bank has paid an amount in excess of rupees 8.48 crores toward the land revenue and property taxes in relation to the worldly property since purchase thereof. Copies of the said letters dated so and so, these are, your lordship can make a note of it, page 99 to 103, all these letters have been annexed, showing, my lord, the amount of money we have paid. Then para 17, further, the condition of the worldly property has deteriorated substantially during the pendency of the legal proceedings, as would be evident from the photographs taken in February and November 2016 and July 2023, which are annexed herewith and marked with the letter H. Well, this perhaps your lordship will be pleased to find in your lordship. I don't know how good these copies are. My copies are not very decipherable, but maybe your lordship has got colored copies. But pages 110, 111, your lordship sees that the trees are growing through the walls. And my lord, also, your lordship can also see the damage which has been done to the wall by reason of long, my lord, keeping this particular property in a fallow state. So all these documents are there. Then, my lord, para 19, that although deprived of the benefit of monetizing the worldly property for the last 4 years or so, para 18, sorry. The applicant has also appointed an agency to conduct a structural survey, para 18, of the building in December 2020. And in such report, it has been observed that various distresses have developed in the building structure, and major repairs are required to restore the building in sound structural condition. A copy of the said assessment report is annexed. This is at pages 125 to 128. The applicant, although deprived of the benefit of monetizing the worldly property for the last 4 years or so, in view of the said order, it has to continue to incur several recurring costs in relation to the worldly property, including the electricity charges, housekeeping charges, maintenance, insurance charges, deployment of several security guards at the property, etc., among others. This entails recurring expenses for the applicant, and in the last financial year alone, the applicant has incurred recurring expenses in excess of Rs 21 lakhs, as apparent from the chart enumerating such expenses. This is at page 129. The applicant craves leave to refer. Then, para 20, the applicant states that in the immediate future, it is required to spend a substantial amount of public money, which even at a conservative estimate will not be less than Rs 4 crores, if not more, for carrying out major repairs to the property to restore its structural soundness. Apart from the continuing costs, para 21, which the applicant is likely to incur in the near future, the applicant has already spent approximately Rs 10.3 crores towards payment made on account of pending electricity charges, property tax arrears, security guards, housekeeping, upkeep, and maintenance of the worldly property, as also conducting periodic valuation and structural audit of the said property since 2016. In view of the supervening circumstances elaborated herein above, the applicant states and submits that the order ought to be vacated by this honorable court and a leave ought to be granted to the applicant to sell or alienate or dispose of the worldly property for the following reasons. And the reasons have been given. If I may just place, my lord. This is, my lord. First is the applicant had taken steps for enforcement of its security in terms of the provisions contained in the SUVRA Act and SUVRA Act in respect of the worldly property pursuant to the leave granted by the Honorable Court by its order dated 12 February 2016 and September 9, 2016. The said orders were passed in vacating application filed by the applicant, and upon hearing all the parties before it, including the official liquidator and Smith's Capital Market Limited, the issues agitated in the Smith's application regarding alleged improprieties in the transfer of certain properties from DIL, that is Dunlop India Limited, to inter alia respondent number 1, and the orders of the company court and the appellate court in that regard were placed for consideration before the Honorable Supreme Court, and the orders allowing auction of the worldly property under SUVRA Act were passed after due consideration of the pleading and submission of all parties. Well, this is what I wanted to submit to your lordship, that the Supreme Court was in the know of things. And my lord, even though the allegations were made with regard to fraudulent preference and other allegations with regard to impropriety in the conduct of the sale, the Supreme Court nonetheless, first of all, directed me to furnish security to the extent of Rs 520 crores, which I furnished, and thereafter the bank guarantee which was furnished was directed to be returned to me. And I was allowed to, my lord, sell the property and hold the sale proceeds subject to the order of the court. I am holding the sale proceeds subject to further order of the court. But at the same time, I am also holding the property. Which property is deteriorating, which my lord has prompted me to come before your lordship. Then my lord B, further, in the order dated September 9, 2016, the Honorable Supreme Court, while directing return of the bank guarantee provided by the applicant, has categorically held that in the event of sale of the worldly property, the sale proceeds are to be dealt with in accordance with law, thereby restricting the alleged claim of the creditors of the company in liquidation. And this is what I said, to the sale proceeds. It is stated that all this time, all that this means is that once the sale takes place under Section 13 of the SUVRA Act, the provisions of Section 13(9) have to be followed, as has been laid down in judicial pronouncement in Pegasus Assess Construction and Haryana. Well, this particular judgment is of great importance. Well, our respectful submission is this, that by reason of this judgment, once, my lord, under the SUVRA Act, if the provisions of SUVRA Act has, my lord, been had been employed in respect of a particular company, then the jurisdiction of all other court is excluded altogether. In other words, the company court has jurisdiction to deal with the company in winding up, no doubt about it. But insofar the sale of this property is concerned, if it is covered with the SUVRA Act, and in terms of that, if the property is sold, then, my lord, the company court will say, well, hands off. I am not going to touch this. Because, my lord, by reason of the provisions of the SUVRA Act, all other provisions of law, my lord, had been excluded. If your lordship, my lord, kindly looks at this is what has been said, and this is what has been, my lord, what has been held in, my lord, Pegasus' case. Your lordship kindly comes to section 35.
Facts were before the division bench when the matter was allowed, isn't it? When the interim was granted.
Yes,
these,
well,
these are not subsequent events.
no, it's not subsequent event, but, my lord, unfortunately, well, I don't want to put it in that way. My lord, Pegasus was cited, but, my lord, that was not referred to in the judgment. In the judgment, my lord, which was delivered by your lordship, my lord, that particular judgment relied upon section 37 for the purpose of asserting that, my lord, the company court does not lose jurisdiction. But then again, my lord, this perhaps is not in consonance with the Supreme Court judge. Supreme Court said no. Once, well, kindly take the section, kindly take section 35 first. 35 is the provisions of this act to override other laws. The provisions of this act shall have effect, notwithstanding anything inconsistent therewith, contained in any other law for the timing in force, or any instrument having the effect by virtue of any such law. Then, my lord, kindly go back to section 34. Civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered or empowered by or under this act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act or under the Recovery of Debts Due to Bank and Financial Institution Act 1993. My lord, kindly come to section 37. Your lordships were pleased to rely upon section 37 for the purpose of negating section 34 and 35. What was held by your lordship is, in terms of section 37, application of other laws not barred. The provisions of this act or the rules made thereunder shall be in addition to and not in derogation of the Companies Act 1956. So, my lord, this, my lord, according to your lordship judgment, my lord, keeps alive the jurisdiction of the company court in respect of any company in liquidation. So, my lord, this will be in view of this, according to your lordship, section 34 and 37 perhaps will not stand in the way. But this, perhaps, in my respectful submission, is not in consonance with the Pegasus judgment, which was cited. This is what, my lord, not in derogation of the Companies Act 1956 or the securities, etc. So, my lord, this question came up for consideration before your lordship in that matter, and here I shall presently draw your lordship's attention to the relevant page of 2016 4 Supreme Court cases. If your lordship kindly comes back to page 11 of my petition, and this is what I have said. It is stated, kindly take the first sentence at page 11. It is stated that all that this means is that once the sale takes place under section 13 of the SUVRA Act, the provisions of section 13(9) have to be followed, as has been laid down in judicial pronouncement in Pegasus. In such judgment, the Honorable Supreme Court has unequivocally held that Section 9, read with Section 13 of the SURFACI Act, leaves no doubt that a secured creditor may enforce security interests without court intervention. It has been further held therein that SURFACI Act overrides the effect of other laws, including the Companies Act, and that the official liquidator's role after a winding up order has been passed and after steps have been taken under Section 13(2) of the Act of 2002. Act is limited by Section 13(9) of the 2002 Act to only providing the figure of workers' dues. Therefore, beyond such scope, the official liquidator has no part to play in private sale under Section 13 of the 2002 Act. And in view of such unambiguous and clear dictum laid down by the Honorable Court, the said order ought to be vacated and modified suitably by this Honorable Court. And you may not give me 1 second. You should just check up. Now, my lord, subparagraph C at page 11. Further, the sale of the worldly property has taken place in terms of Further, the sale of the worldly property has taken place in terms of the provisions contained in SURFACI Act. Section 34 of SURFACI Act provides that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which a debt recovery tribunal or the appellate tribunal is empowered by or under the said act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power referred to under SURFACI Act or under recovery of debts due to bank and financial institution act. In the instant case, admittedly the sale took place in terms of SURFACI Act. Further, the applicant has also filed an application under Section 19 of the 1993 Act. Accordingly, an order of injunction could also have been passed by any court. No order of injunction could also have been passed by any court or tribunal, including the Court of Appeal. The said order which has passed in this appeal proceeding is also in the nature of interim order, as has been directed by the that the interim order is to continue till disposal of Smith's application. The Honorable Supreme Court has, in its judgment, delivered in criminal appeal number so and so in Asian Resurfacing of Road Agency Private Limited, and in particular para 35 thereof, unequivocally held as follows. In cases where stay is granted in future, the same will end on expiry of 6 months from the date of such order, unless similar extension is granted by a speaking order. The speaking order must show. Oh, it overruled. I am told, my lord, this has been overruled. I am not going to place it for lordship. I am told, my lord, the juniors are very up to date about these things, my lord. What happened yesterday, I didn't know. Excepting that I know, my lord, Sheikh Shah Jahan has been arrested. Apart from it, nothing else I know about.
Yes, my lord, in Asian Resurfacing of Road Agency, it has been over.
Oh.
But I was about to show that. Now, since he's not taking the point, I won't show.
Then, my lord, E. Smith's application from which the instant appeal emanates is not maintaining the facts and law, etc. Well, I am not troubling your lordship. I will just refer your lordship the judgment of dated 29 January 2019. Now, acha, I will tell you. Well, at first, I show to your lordship the. না ঠিক আছে ছেড়ে দাও আমারটা মার্ক করা রয়েছে তো তুমি বলে দিও আমাকে কোথায় কোনটা দেখাতে হবে kindly come to para 1. This is a judgment which has been delivered by a division bench consisting of Mr. C. Vikramjit Sen and Mr. C. Shivakranti Singh. Shivakirti Singh. My lord, Shivakirti Singh, Justice, my lord, he delivered the judgment. A common issue of law, whether a company court, directly or through an official liquidator, can wield any control in respect of sale of a secured asset by a secured creditor in exercise of powers available to such creditor under securitization and reconstruction of financial assets and enforcement and security arises in all such matters which have been heard together and shall be governed by this common judgment. So that was the issue which was there before the court. My lord, kindly come to paragraph 14. There's a detailed discussion about it. I will just place it before I place your lordship's division bench judgment. Paragraph 14. As the case of Pegasus has been argued as a lead matter, we propose first to consider the view of Punjab and Haryana High Court. After noticing the statement of objects and reasons for enactments of SUVRA Act as discussed by the company judge, the division bench took note of detailed argument advanced on behalf of Pegasus, which is to the following effect. Section 5 of SUVRA Act provides for acquisition of the rights or interest of financial assets of the bank or financial institution by any securitization company or reconstruction company, inter alia by entering into an agreement. And this section begins with a non-obstante clause. Section 9 enumerates various measures which can be adopted by a securitization company or reconstruction company, including the sale or lease of a part or a whole of the business of the borrower. And this section also begins with a non-obstante clause. Chapter 3 consists of 7 sections providing for enforcement of security interests created in favor of the secured creditor. Section 13, which also begins with a non-obstante clause of a limited nature for overcoming the hurdles of Section 69 or Section 69A of the Transfer of Property Act, creates a right in the creditor to enforce any security interest in its favor without the intervention of the court or tribunal, in accordance with the provisions of this Act. The detailed scheme for enforcement of the secured assets under various subsections and provisos in Section 13 were pointed out, along with Section 35 and 37, in support of the submission that the provisions are not only a complete code for enforcement of secured asset by a secured creditor, but in case of conflict with any other statute, the provisions of SUVRA Act would prevail. Some other statutes enumerated in Section 37 can play a supplemental role. Kindly note this. Supplemental role along with any other law for the time being enforced, including the Companies Act. But obviously, only till they are consistent with the provisions of the SUVRA Act. The relevant case laws are also cited and considered. The rival contentions were noted framing the question of law. I am not troubling your lordship. Then the para 16 is the division bench of the Punjab and Haryana court had been noted. And my lord, with regard to, paragraph 16 is only referring to the judgments which were cited. Then, my lord, para 17 says we are unable to subscribe to the aforesaid views. On the other hand, after going to the judgment of Delhi High Court in so and so, we are persuaded to approve of its views because of various reasons, some of which we shall enumerate and explain hereunder. The para 18, my lord, the different case laws have been discussed. Then, para 19, discussing the Delhi High Court judgment. Then, my lord, para 20, different acts have been considered. Then, 21 is RDB Act of 1993, later to the Companies Act. So, Companies Act has also been taken note of. Then, my lord, para 22. In contrast, the SUVRA Act was enacted in 2002 to regulate securitization and reconstruction of financial assets and enforcement of security interest, and for matters connected therewith or incidental thereto. Inter alia, one of the main objects of this Act is to clothe the banks and financial institutions in India with power to take possession of securities and to sell them. All its significant provisions have been noted in detail in Madhya Chemicals. Then, 23. A reading of Section 9 and Section 13 of SUVRA Act leaves no manner of doubt that for enforcement of its security interest, a secured creditor has been not only vested with the powers to do so without the intervention of the court or tribunal, but detailed procedure has also been prescribed to take care of various eventualities, such as when the borrower company is under liquidation, for which proviso to subsection 9 of section 13 contains clear mandate, keeping in view the provisions of section 529 and 529A of the Companies Act 1956. Since significant amendments were introduced in section 529 while inserting section 529A through Amendment Act of 1985, effective from 24/5/1985, and with the aid of non-obstante clause in subsection 1 of section 529A, workmen's dues were given preference over other dues and made to stand pari passu with the dues of secured creditors. So this is, my lord, the exception. This, my lord, had been taken note of by the Supreme Court. He said, apart from this, touch me not. That was the principle. And then, my lord, it says, in case of apparent conflict, this court, through various judgments, has upheld the proceedings under RDB Act, as it happens in a later act, with overriding effect of other laws. The interest of the workmen in respect of the dues payable to them, as per section 529 and 529A of the Companies Act, has been protected by permitting, wherever necessary, association of the official liquidator with the proceeding before the Debts Recovery Tribunal under the RDB Act. In our considered judgment, and this is the judgment, in our considered judgment, the same view is required to be taken in context of the SUVRA Act also. For the stages which in the case of a company under winding up, being a borrower, would mean requirement of notice to the official liquidator. The Security Interest Enforcement Rules 2002, framed under the provisions of SUVRA Act, also require notice upon the borrower or his agent at different stages. For sale of immovable secured assets, as per Rule 8, the authorized officer can take possession by delivering possession notice to the borrower and by affixing possession notice on the outer door at some conspicuous place of the property. Before the sale also, the authorized officer is required to serve to the borrower a notice of 30 days. Thus, the rules also ensure that the official liquidator is in the knowledge of the proceedings. In our case, my lord, official liquidator had been kept in the knowledge of the proceedings, including, my lord, publication of advertisement for auction sale throughout. Under the SUVRA Act, in case the borrower happens to be a company under winding up, as a borrower, the official liquidator has ample opportunity to get the details of the workers' dues as ascertained under the Companies Act, placed before the authorized officer, and seek proper distribution of the amounts realized from the sale of secured assets in accordance with the various provisions under subsection 9 of section 13 of the SUVRA Act. The above discussion supports the view taken by the Delhi High Court, and no order is required by the company judge for association of the official liquidator in order to protect the interest of the workers and to realize the dues. Sufficient provisions have been made. Then, my lord, in the event, paragraph 25, in the event in the capacity of a borrower, the official liquidator is not satisfied with the decisions or steps taken by the secured creditor or the authorized officer, at appropriate stage, it has sufficient opportunity to avail the right of appeal under section 17 of the SUVRA Act. So official liquidator also will have to come under the SUVRA Act before the Debts Recovery Tribunal. There is a right of further appeal under section 18 before the Appellate Tribunal. On the other hand, if the view taken by the Punjab and Haryana High Court in Pegasus is accepted, there shall be a conflict of rights and interest of the secured creditor who have the right and liberty to realize their secured interest in accordance with the provisions of the SUVRA Act on the one hand, and the statutory rights and liabilities of official liquidator acting under the order of the company judge, as per the provisions of the Companies Act on the other. The appellate fora shall also differ, leading to a situation of uncertainty and conflict between the two acts. In such scenario, we respectfully agree with the Delhi view and disapprove of the Punjab and Haryana High Court. My lord, I pause here for a moment. This completely answers this concept of the official liquidator being in charge of a company in winding up. The fact that the official liquidator is in charge of the company in winding up entitles the official liquidator to approach, my lord, the debt recovery tribunal with an application under section 17 for the purpose of intervention. So, my lord, what has happened is this Supreme Court judgment, rightly or wrongly, has held that insofar as the Securitization Act is concerned, this is a superseding act. In other words, this will have in a priority over any other act, including the Companies Act. Even though under the Companies Act, the liquidator is the person in charge of the company liquidation. That is why it says that if the official liquidator acting under the orders of the company judge is doing anything, you will have to approach, my lord, this debt recovery tribunal. Then, my lord, coming the case laws, I am not troubling your lordship. Para 26, these have been considered. Para 26, 27, various judgments have been considered. 28, 29. Then, my lord, para 30. I am not going to trouble your lordship with that. Here, my lord, various judgments have been discussed. Para 30. Para 30 Virat judgment. My lord, kindly come to para 30, placitum B. Placitum B in that paragraph. After, my lord, saying the Delhi High Court's view, which, my lord, the Supreme Court has approved, it says that for the purpose it has been enacted, it is a complete code. My lord, it is talking of this act. For the purpose it has been enacted, it is a complete code, and the earlier judgments rendered in the context of SFC Act or RDB Act, vis-a-vis the Companies Act, cannot be held applicable on all fours to the SUVRA Act. There is nothing lacking in the Act so as to borrow anything from the Companies Act till the stage the secured assets are sold by the secured creditor in accordance with the provisions of SUVRA Act and the rules. Then, my lord, kindly come to placitum G. Placitum G, the sentence starting with the words in view of. In view of such exercise already done by the legislature, there is no plausible reason as to take recourse to the provisions of the Companies Act and permit the interference in the proceedings under the SUVRA Act, either by the company judge or the liquidator. As noted earlier, the official liquidator, as a representative of the borrower company under winding up, has to be associated not for supplying any omission in the SUVRA Act, but because of express provisions therein, as well as in the rules. Hence, the exercise of harmonizing this court had to undertake to the context of SFC Act or RDB Act is no longer warranted in respect of the SUVRA Act vis-a-vis the Companies Act. Then 31. The aforesaid view commends itself to us also because of the clear intention of the Parliament expressed in Section 13 of the SUVRA Act, that a secured creditor has the right to enforce its security interest without the intervention of the court or tribunal. At the same time, this Act takes care that in case of any grievance, the borrower, which in the case of a company under liquidation would mean the liquidator, will have the right of seeking redressal under Section 17 and 18 of the SUVRA Act. So, my lord, the liquidator will have to take recourse to the SUVRA Act for the purpose of amelioration of any grievance. My lord, I do not want to trouble you. The rest of it, my lord, so this was, my lord, the Pegasus judgment which has been referred to. what I am on is this, that now that the security interest of the bank has materialized in the form of a property which has been acquired by the bank. Now the bank is coming up to your lordship and saying that I've got to maintain this particular property, but I am unable to maintain this property because of the huge expenses that is being incurred, and I am not being able to move at all in view of the order of the division bench of this honorable court. So that is why we have come before your lordship with this application. Now, a question may arise that why should you not go back before the company court? Why trouble us? We'll have to trouble your lordship because of, my lord, the situation that is arisen. What I am feeling after reading this judgment, which I am going to presently place before lordship, I don't know whether your lordship will have the time to do that. My lord, this judgment, this is after all division bench judgment. Division bench judgment has, my lord, made various observations. Now, if with these observations and with this order, I go back before a learned single judge of this honorable court, namely the company judge, for the purpose of, my lord, adverting to my grievances, for the purpose of vacating this order. Well, I am just looking at it from the psychological point of view. There will be an inherent reluctance on the part of the trial court.
Nothing has been decided on merits by the revision bench.
But then again, my lord, kindly see what the court has said.
And another thing I'm tempted to point out, the first order where the interim order has been granted.
Yes, my lord.
Page 18.
Yes, I'm coming to that. Lordship, yes.
The interim order says without previous leave of the court. So have you sought leave of the court for dealing with the property in any manner?
The immediate
You
dispute.
asked for a blanket vacating of the order. You could have dealt with the property.
Well, this order has marched into the final order. This is an interim stage, really at interim stage. Can you read this order, page 18, paragraph 2?
Even if this is the final order,
This is,
you have taken leave of the court.
well, this will it be necessary to obtain leave of the court? Kindly see, if I may place these two orders one after the other. This is, my lord, kindly note, this is dated, my lord, 10th October 2018.
Yes.
It says the appellant is one of the several unsecured creditors of the company in liquidation and claims that the worldly property may have been unlawfully transferred by the erstwhile management of the company in liquidation. ICICI Bank Limited is the principal respondent and says that since the application of the creditor appellant before the company court was not maintainable, the present appeal is also impermissible. Without prejudice to the point of maintainability taken by the ICICI Bank Limited, there will be an interim order restraining ICICI Bank Limited from creating any rights or further rights in respect of the worldly property or any part thereof in favor of any person without the previous leave of the court. This is the leave I am asking for. I am applying before your lordship. This leave, my lord, the trial court could not have given. I am asking for your lordship's leave that kindly allow me to sell the property or to deal with the property, which I cannot do so long as this particular order and the final order remains. This is the application.
Your prayer is for vacating the interim order
Yes,
altogether.
yes. But my lord, without the leave of, I think
there's a subtle difference between the two.
my lord, I will
Because
submit
my
your lordship. Technically,
You really decided to deal with the property and the details are given before the court.
yes, and this is what I must. When I have come before your lordship, allow me to do this. That means I am asking from your lordship's leave.
That's a
Kindly
blanket.
give me permission to do this.
Ask for a blanket order.
No, not.
Property in any manner.
No, that is the leave I'm asking. I am praying before your lordship that granted me permission to deal with the property in any manner. This is what I am asking for. I cannot ask for this. If I go before the trial court, before the company judge, the learned company judge will say, you are supposed to obtain permission from the appeal court. Why have you come before me? So I am moving before my lord from pillar to post. Kindly see the last sentence. there will be an interim order restraining ICICI Bank Limited from creating any rights or further rights in respect to the worldly property or any part thereof in favor of any person without the previous leave of this court. I am submitting to Lordship, this is the leave I am asking for. This is the prayer. I am asking.
The blanket vacating of
No,
order.
I am asking.
Not specified how you want to deal with the property.
Well, if
Intending purchasers, what the details.
well, if I may say so with respect, that if I am the owner of the property, and if I have to go back, I tell you, Lordship, what? Ultimately, this particular application has been necessitated by the order of the division bench, which has been passed, my lord, on the 29th of January, the final order. I could not have gone before any other court so long as this order remains against me. It is staring me at my face. Without the leave of the division bench, you cannot sell the property. If I go before the trial court of company court, they will send me back before Lordship. They will say, go obtain the permission of that court first. That is why I am before your Lordship. Well, this particular order at page 19 is, my lord, standing in the way. Therefore, I cannot do anything. My lord, kindly see if your Lordship now kindly comes to page 19. I will make myself, I will rest my case after I place the judgment. And I have given your Lordship the background. I have shown to your Lordship how I became the owner of the assigned rights in respect of this Mumbai property. I have shown to your Lordship that I have got the blessings of the Supreme Court at every stage of the sale. I have shown to your Lordship that we have tried our level best for the purpose of obtaining a purchaser. I have shown to your Lordship, in spite of 4 attempts made, my lord, a purchaser could not be had. I have shown to your Lordship the property had to be sold to myself. And when I sold the property to myself, I went to the Supreme Court. Supreme Court not only permitted me to sell the property, said that the amount of deposit that you have made by your security which you have furnished, you take it back. But what you do is this, so far as sale process is concerned, I am putting an embargo on that. That is to be decided by the company court as to how the sale process is to be decided. So far as the property is concerned, the actual property, the Supreme Court gave me a free hand. And today I have come before your Lordship, my lord, after waiting for the matter to be taken up sometime or the other, I found that I cannot have it heard. And again, my lord, I tell you, Lordship, very frankly, I also advise my client that if you go before the company court for the purpose of obtaining relief, the first point the court will say is this: you are to obtain the permission of the division bench. Why have you not gone before them? That is why I'm troubling your Lordship. This bench has to be constituted. Your Lordships have been taken away from the regular determination. And, my lord, your Lordships are hearing this matter only because, my lord, I felt that perhaps this matter cannot be tackled by the learned company judge single-handedly. 2 senior judges have, my lord, passed an order. Who has got the temerity to interfere with that? I put it this way. My lord, kindly do not mind me putting it this way. This is exactly, my lord, the feeling, the psychological feeling that one will have. My lord, kindly come to page 20.
20?
Yes, 20. This is the judgment of this, of your Lordship. The appeal is of limited import. It arises out of an ad interim order dated 5th September 2018, passed on the appellant's application in winding up proceeding pertaining to Dunlop India. The appellant is aggrieved by the refusal of the company court to grant interim protection in what the appellant perceived to be a fraudulent act and a scam by the respondent ICICI Bank Limited. By the order impugned of 5th September 2018, the company court noticed the strong objection raised on behalf of the ICICI Bank as to the maintainability of the application and certain orders of the Supreme Court passed on 12 February 2016 and September 9, 2016 in proceedings arising out of special petition filed from a division bench order of this court confirming the liquidation of Dunlop India Limited before declining an ad interim order. The effect of refusing the order is that even if the application ultimately succeeds, the valuable property may no longer be recovered as irreversible changes could be brought about by third parties. Well, here, I pause here for a moment. After the Supreme Court order, which I showed to your lordship, I thought that, my lord, the interest of the creditors and contributories have shifted onto the sale proceeds, which the Supreme Court said not to be touched until, my lord, some order is made by the company court. In so far the property is concerned, property was released to be dealt with by the party concerned. By the order impugned on 5th September 2018, the company court noticed the strong objection raised on behalf of the ICICI Bank as to the maintainability. I've read it. Then, my lord, next paragraph. It is submitted on behalf of the appellant that the factual basis as recorded in the second paragraph of the order impugned is erroneous on the face of it, and the relevant order to the Supreme Court did not preclude the company court from entertaining the appellant's application. As to the objections on the ground of maintainability, the appellant says that the order impugned does not indicate even a prima facie appreciation of how the company court, in season of winding up proceedings against a company in liquidation, could be said to lack authority in collecting or protecting the assets of concerned company in liquidation. The complete answer is Pegasus. This, my lord, I respectfully submit to your lordship, may not be correct, quite correct, my lord, in view of the Pegasus judgment. It says that it would not be said as to lack of authority in collecting and protecting the assets of the concerned company liquidation. Pegasus said exactly to the contrary, that you will have to go back before the debt recovery tribunal. And the official liquidator is also to go back before that tribunal. When this appeal was received on 5th October 2018, it was the same ploy that was adopted by the respondent bank. A point of maintainability was taken, both regarding the present appeal and the application before the company court. On October 5, 2018, the respondent bank was required to indicate the status of the worldly property, which is the subject matter of the application and this appeal. On October 10, 2018, ICICI Bank claimed to be in possession of the worldly property. An ad interim order was passed in this appeal on such day in the following terms. Without prejudice to the point of maintainability taken by ICICI Bank Limited, there will be an interim order restraining ICICI Bank Limited from creating any right or further rights in respect of the worldly property or any part thereof in favor of any person without the previous leave of this court. During the several weeks thereafter, that this matter meandered through the most of the time has been taken on account of adjournments sought on behalf of the respondent bank. Several of the adjournments have not even been formally recorded. The initial adjournments may have been sought by the respondent bank to proceed with special leave petition from the order dated 10th October 2018. However, such petition has since been dismissed. Well, this was not dismissed in that sense. It was withdrawn. Anyway, the ground of maintainability which has been raised is not so much as to the present appeal, but as to the application carried before the company court. Section 34 of the Securitization and Reconstruction of Financial Assets and Enforcement Security Interest Act 2002 has been stressed on by the respondent bank to emphasize the two limbs covered by such provision. The first, prohibiting a civil court from entertaining any suit in respect of any matter which a debt recovery tribunal or an appellate tribunal is empowered to determine under the Recovery of Debts, etc. Act or the said Act of 2002. And the second, restraining any injunction being issued in respect of such matters. To boot, Section 35 of the Act of 2002 is placed on behalf of the respondent bank to demonstrate that non-obstante clause therein would make Section 34 of the Act override all provisions of the previous enactments. All such initial submissions on behalf of the respondent bank was without reference to Section 37 of the Act of 2002. This perhaps is not quite correct because Section 37 has been taken note of in Pegasus' judgment, specifically taken note of. And the preservation of the provisions inter alia of the Companies Act 1956 by such provision. Upon an interjection on behalf of the appellant to point out Section 37 of the Act of 2002. The respondent bank has spent several days in quoting from venerable textbooks on interpretation of statutes and citing several judgments, even from beyond these shores, to assert that when a right is created for the first time, if such right did not previously exist in common law, the right had to be exercised in the manner as created by the statute and in no other form. Despite being pointed out to the respondent bank at the outset that the principle was clearly inapplicable, several days of hearing have been wasted to flog a dead horse. Well, it seemed, I mean, this is my feeling, kindly pardon me for saying so, that when your lordships were hearing this particular matter, the suspicion was created in the mind of the court that this particular property came into the hands of the bank, ICICI Bank, in a not so clean a way. I think, my lord, to put it very mildly, I thought, my lord, that is the impression I got when I read this judgment. I was not there before the court, of course, at that time, but that is the impression that I got. And so, my lord, the court was of the view that perhaps this particular transaction with regard to sale of the property should, my lord, be put to scrutiny before the company court. That was the feeling that was there. According to the respondent bank, Section 17 of the Act of 2002 confers a right on any person, including a borrower, to question the measures taken by a secured creditor under Section 13(4) of the Act of 2002, if such person is aggrieved thereby. The respondent bank asserts that such right did not exist prior to 2002, and as such, if any person is aggrieved by the measures taken under Section 13(4) of the Act of 2002 by any secured creditor, the only remedy would be under Section 17 of the Act and in no other manner. This is what Pegasus said exactly. Prima facie, the contention is exceptionable. The Act of 56, to the extent that it is still operational in respect of companies wound up by the court, hoists a duty on the company court to protect the assets of a company in liquidation, and at any rate confers the authority to receive a complaint from a creditor or a contributory of a company in liquidation that any asset of the company in liquidation has been fraudulently transferred and such asset needs to be recovered. Such a prayer can be entertained by a company. This is where, my lord, I am joining issue. I say this is exactly what has been held by Pegasus, that company, if the liquidator is of the view that there is a fraudulent preference in respect of a particular transaction, he will have to go before that authority, that tribunal. Such a prayer can be entertained in the company court in size of the authority under 19. And even the relevant property recovered in course of winding up proceedings. If the company court has such authority, any person interested has a right to invoke such jurisdiction. It is a statutory right that has been left unaffected by the Act of 2002. This is totally contrary to, my lord, Pegasus's judgment in the Supreme Court. In the present case, the contention of the appellant is that a property that belonged to the company prior to its liquidation, as on the date on which the first creditors of the winding up was filed against the company, was sought to be alienated or transferred during the pendency of the winding up proceeding, which culminated in an order of winding up being passed. The law under 1956 Act is that when an order of winding up is passed, it relates back to the date of the institution of the petition. The other part of the appellant's submission pertains to the perceived fraudulent conduct of the erstwhile management of the company and how the respondent bank may have been hand in glove with such recalcitrant erstwhile management. It must also not be missed that the right of the appellant canvass in its representative capacity as a creditor of the company in liquidation and not exclusive from himself. Once an order for winding up was passed in respect of a company by the company court, before the introduction of the more adventurous statutes as the recovery of debts, etc. of 2002, the Act of 1956 envisaged that the official liquidator attached to the relevant company court would be solely responsible for all assets and properties of the company in liquidation. Such official liquidator functions, subject to the direction of the relevant company court, and such company court is empowered to protect all assets of the company in liquidation, undo the acts of fraudulent preference, and recover assets sought to be alienated illegally to ensure that the interests of the creditors of the company in liquidation are not prejudiced. The introduction of the Companies Act 2013 has not altered the position pertaining to the companies already in liquidation. Here again, my lord, I am joining issue. I say that Supreme Court says otherwise. The extraordinary jurisdiction pertaining to companies in liquidation vested in the Company Court by the Act of 1956 cannot be overstated. Section 46 of the Act of 56, for instance, requires leave of the relevant Company Court to be taken in respect of any other suit or proceeding that may be instituted or proceeded with against a company in liquidation. In course of such leave being granted, it is also open to the Company Court to require the proceedings to be instituted or transferred before itself. The width of Section 446 of the Act and the subsequent provisions pertaining to companies in liquidation cannot be undermined. While it may not be unusual in this court, which otherwise exercises ordinary original civil jurisdiction for a suit proposed to be instituted against the company in liquidation, to be required to be filed before the Company Court. Here again, the leave under Section 446 of 1956 Act is sought. Which judgment is posted to the Pegasus judgment. Yet contrary to this.
Will
There-
this be very relevant for the present application?
Well,
We are not actually sitting in appeal over this.
No, your lordship is not. But then again, my lord, this is my, if I may say so, this is my roadblock, so to say. Because so long as this order remains, well, I will not be able to. That is why I have come before your lordship. This, your lordship is perfectly right. Strictly speaking, it is not necessary. But then again, kindly see the ultimate paragraph at page 28 or 29, I should say, 27. The last paragraph of that. The simple complaint of the appellant creditor of the company in liquidation before the Company Court is that one of the most valuable properties of the company in liquidation had been sought to be alienated at a time when the law prohibited it, and for little or nothing by way of consideration. This was the allegation. If there are roadblocks on the ground of maintainability, such roadblocks need to be addressed by the Company Court to assess whether the merits of the matter can ultimately be addressed. Since it prima facie appears that the issue of maintainability asserted on behalf of the respondent bank may be a red herring, only to try and dodge the core issue being addressed on merits, the entire matter is left for consideration of the Company Court and for the decision in accordance with law. Of course, one has to go back before the Company Court for the purpose of deciding. But this roadblock remains. The observation is tentative without prejudicing the rights and two leading parties in the appeal, without prejudicing the rights and interested parties. And my lord, and kindly see the last paragraph, disposed of by continuing the order passed on 10th October as quoted herein above. Such order will remain in force. My lord, I am submitting to your lordship two things I am submitting, both on the basis of Supreme Court. Supreme Court order said that the property can be sold, and it had been sold in favor of the bank. Supreme Court really put the embargo upon the sale proceeds. That is the last order your lordship has been pleased to see, which I have shown to your lordship at page, yes, kindly come to page 75.
Yes.
Second sentence in the order. If the property has been sold in the meantime, the proceeds thereof shall be dealt with in accordance with law. The official liquidator will take necessary steps. Any of the contesting parties will be at liberty to approach the official liquidator in this regard. So it is with regard to the sale proceeds. So, my lord, insofar as the embargo created with the Supreme Court on the property is concerned, that was lifted altogether. So I am submitting to your lordship, relying upon this Supreme Court order, that this embargo, which is now, my lord, at page 28 of the, my lord, at page 28, which is confirming, my lord, the earlier order at page 18. I say, my lord, this should be lifted in view of the Supreme Court order. Number one. Number two, Pegasus Conta. Your Lordship will please to, I have already placed it, Your Lordship, on paragraph 23. Kindly, my Lord, come to paragraph 23. My Lord, 23, I have shown to Your Lordship, my Lord, this is the other paragraph I am relying upon for the purpose of assailing this judgment and for the purpose of praying for Your Lordship to lift this thing. It is
really not assailing the judgment.
my Lord.
We are not sitting in appeal. You are not really assailing.
No, I am not. I am saying that lift. I am not my Lord, for a moment saying that Your Lordships are sitting in appeal over the judge. I say that this order has been passed by a division bench.
Please ask for a modification.
Yes, I am saying, my Lord, in view of these orders, the two Supreme Court orders, the embargo which was created in my dealing with the property should be lifted because it is no longer, my Lord, the property which is the subject matter. It is a sale proceed, number one. And number two, more importantly, the Pegasus judgment says that in our considered judgment, the same view is required to be taken in the context of Surface Act also for additional reason section 13. And it says that thus the rules also ensure that official liquidator is in the knowledge of the proceeding under so and so. And therefore, official liquidator will have to approach the court, whether the tribunal, for the purpose of obtaining whatever relief that it wants. If it is not on the record, do not ask me to say anything. I mean, I am going strictly by what is on record. Mumbai থেকে করেছিল
That's all your sufficient.
well, this is that is all.
For the appellant, the respondent number 1 in this application, my lord, may I come back on some other day? My lord?
Can you come back on 14th March?
Yes.
Grateful.
Grateful.
Counsel for the applicant. Paragraph, let the matter appear under the same heading for further consideration on 14th March 2020.
Wow.
Well, if your lordship's convenience, can you 7th March or 14th March there is special?
7th, I'll have 7th rejection, isn't it?
14th there's a specially fixed matter.
I'll have the rejection.
14th or
Then
13th?
21st.
21st.
Take up these matters on
21st.
21st March.
Because my learned friend will not take too long. And I am the added party. My lord.
But I am also there, my lord. I will be making submissions for half an hour.
You're very much there, we are aware.
He is the only substantial counsel in this entire matter.
How are you now? You're better?
Better, my lord. 2 more weeks to go. Then I'll be before your lordship.
All the best. All the best. Come back soon.
Very grateful. Very grateful.
Grateful, my lord.
Grateful, my lord.
21st March.
21st. Thank you. Hey, there.
Original side mentioning for judgment, item number 1.
The writ petition has been dismissed. I'll read out the operative portion. It is crystal clear that since clause 15.15.5 of the resolution plan was not approved by the adjudicating authority, and also since clause 15.3 calls for implementation of the resolution plan by the resolution applicant despite refusal of the approvals, extinguishments and waivers, the WBIDC has rightly raised demand of transfer fee to the tune of rupees 64566,626 by the letter impugn dated 26th April 2022. In view of the fact that the resolution plan in its entirety was not approved by the adjudicating authority or by the appellate forums, the ratio decidendi laid down in the authorities relied upon by the petitioners can be distinguished from that of the present application. It is only upon approval of the resolution plan by the adjudicating authority that the claims laid down therein stand frozen and is binding. So in the above conspectus, this court is inclined to hold that the notices impugned are in conformity with the terms of the resolution plan, and there is no illegality or irregularity therein which calls for interference. The writ petition fails. Articles are
Under Article 226, item number 2.
We beg to appear on behalf of the state respondents, as well as Khadi board.
did you serve the second?
Yes. Khadi board, we are appearing.
You are appearing. Then, my learned friend.
You are appearing.
Lordship,
Lord, I am a very old tenant, Lord, whose cause, Lord, concerning fixation of rent, Lord, came up before this honorable. This honorable court, Lord, directed that, Lord, the question about fixation of the rent in respect of the property that I, Lord, occupy, Lord, is to be decided by the rent controller. That, Lord, will appear, Lord, at page 21. The order starts at page, Lord, 20, and the page 21, about, Lord, 6th line from top.
Yes.
The rent controller shall decide the fair, reasonable rent in accordance with the law, taking into consideration the occupancy of the tenants in the premises. Therefore, my lord, it was considered to be, my lord, a tenancy governed under the West Bengal Premises Tenancy Act, my lord, even by this honorable court. Then, my lord, your lordship will kindly come to, my lord, page 22, my lord, the Supreme Court's, my lord, order. But this was, my lord, a SLP by, my lord, West Bengal Khadi and Village Industries, my lord, board against my client. The petitioner before your lordship, my lord, the special leave petition, my lord, as against, my lord, the division bench order at pre-page, Lord, that stood dismissed. Now, Lord, there was, Lord, an offer by my client, Lord, which was accepted. Lord, your lordship will kindly come to, Lord, the offer at page 24. 24. Yes. So, Lord, I had given them all offer letter fixing, Lord, the rate of rent, and that was accepted by, Lord, the respondent.
Now, my lord, at page 45, my lord, a notice was given. Page 45. Where the notice is, not 2023, 21st of February. Whereas a memorandum of understanding was signed between the West Bengal Khadi and Village Industries Board and your end dated nil, and whereas the rate agreed between both the parties found to be at lower end in comparison to the present validation of the occupied place within the premises being number such and such. Whereas the board considers to review different clauses of the said MOU. You are hereby requested to inform this office as to why the board will not decide for enforcement of rent as per market basis. Your reply should reach within this office within 24/2/2023. Now, my lord, we gave an answer at page 46 that we are agreeable to enhance from 5 to 10% on the present rent which we are paying. Now, my lord, a bill was raised at page 47. The bill, my lord, that they have raised is a rent bill from 1st January 2023 to November 2023. This is raised on 4th of December 2023. For floor space occupied by your company submitted for taking necessary action towards payment of the same at the earliest. Now, my lord, the rent, the area has been marked. The current rate, my lord, they say is 45,000 and odd. Then, my lord, the total bill amount, and my lord, the remarks is, and they, my lord, ask for, my lord, the amount payable under the bill. The remarks is rent fixed per month rupees such and such by first land acquisition collector Kolkata number such and such dated such and such. He doesn't have any right. Because, my lord, it is a decision of this honorable court, the division bench. Because, my lord, possibly, subject to correction by my learned friend, they were not trying to, the board being a lot of instrumentality of a state, they thought that West Bengal Valuation Boards Act will apply, and Lord, the collector is the person who can Lord fix the rent. That is Lord subject to what my learned friend says. That is my anticipation.
Right.
Yes. So Lord, they went before the valuation, Lord, for valuation, rental valuation, or before the land acquisition. Before the land acquisition collector, I was never invited. If I had been invited, my lord, I could have taken a point of jurisdiction. Secondly, my lord, he fixes, my lord, a rent according to his own whims, which is, my lord, predated. That is, my lord, from 1st January 2023. Now, my lord, this is, my lord, on the basis of this, my lord, they are asking that my client should be paying this amount. Otherwise, they will take possession of the property. We gave a representation, my lord, at page 48.
Yes.
But this is a representation in detail. And Lord, I am challenging basically, Lord, the demand that they have made, and consequent upon the demand, their threat to dispossess Lord from the property. But that is my case.
Lord, your lordship kindly sees, Lord kindly comes to page 20 annexure P1.
Page
20 annexure P1.
20.
Yes. What happened, my lord? The rent was very meager, my lord. We have enhanced it to, my lord, 10,000 per month. My lord, they did not decline. Thereafter, my lord, they came to this honorable court. Single judge, my lord, on his lordship's own discretion, my lord, enhanced the rent at 10,000 per month, and that has been upheld by the division bench of this honorable court. Kindly comes, my lord, ultimate paragraph, last 3 lines. First page, page 20, last 3 lines. As you lordship, we direct, the sentence starts, we direct that as an interim measure. So it's an interim measure. The rent controller under the West Bengal Premises Tenancy Act 1956 to decide the fair rent of the parties after holding both the parties within 2 months from the date of after giving notice to both the parties. This is an interim arrangement. Kindly, my lord, take notes of it. And my lord, the division bench, my lord, said, next paragraph, the appellant shall pay rent at the rate of rupees 10,000 per month. The amount which has been fixed by the, my lord, learned trial court in the midst of while hearing this writ petition. Thereafter, my lord, an out-of-court settlement was made, and agreement has been reached upon both the parties. And my lord, they gave up 1,000 square feet out of my lord 2,000 square feet, and agreed rent was my lord rupees 5,000, subject to correction of my lord.
Yes, you're right.
So 5,000 my lord. So my lord, from 2001 till 2020-24, my lord, there is no eviction of rent. My lord, they are occupying premier position of Dalhousie, Central Calcutta, 1,000 square foot, only my lord 5,000 per month rent. So my lord, that's why my lord, we being the statutory authority, and since my lord, in terms of the definition of the my lord, section 3(4), subsection 4 of the my lord Premises Extending Act, we do not fall under the category my lord of the my lord local bodies, which has been given a definition my lord in the my lord Premises Extending Act. We do not fall under those category. As a statutory authority, my lord, we have approached the LA collector. LA collector, my lord, advised us to seek a report from the Inspector General of Registration for seeking valuation, and Inspector General Registration valued the premise.
You offered an opportunity of hearing to the tenant.
No.
Is there no
The
provision?
fixation of fair rent, my lord, that is not necessary.
Fair rent will not be done in presence of the tenants?
I know. But what we did,
Everything else is left aside.
but what we did, because in terms of the advisory given by the LA collector, we sought report from the valuation board. They assessed for rupees 41 per month, and that's that's had been communicated to the LA collector, and LA collector fixed the rent.
This is all your internal communication.
Yes,
The tenant who has to pay the amount from his pocket has to be informed.
kindly appreciates, they are occupying 1,000 square foot at the rate of 5,000 per month.
Right, you're absolutely correct. But then the tenant has to be given a hearing.
Yes,
That was not given.
lordship, my lord.
So solely on this ground, this has to be set aside.
Because
I
I
agree
think
with you. It was an interim measure, the rent controller.
interim measure, but
They
my lord,
never
there is
approached
no,
the rent controller because,
No, because-
my learned friend's contention, I'll answer.
if you
Because
section
he
301
says this is a local body. Local body is not defined. He's not a local body, my lord. He's not a municipality.
we are a statutory authority.
Says
We
he is
statutory, not a local body.
All within the
My lord,
Lord, even if that be so, my lord,
by special
previously
statute,
this
that board
honorable
has been
court, the
created.
division bench said that there should be, my lord, falling under the West Bengal premises. Lord, that is my learned for page 20. My learned friend has written.
Interim measure.
The interim measure was not for 10,000 rupees, but the determination was relegated to the rent controller.
That is also as an interim measure. Please come, let's come, go through the order once more.
Lord, if your lordship kindly takes
Page 20, we propose to modify this aspect of the order, and instead of Talbot and Company, we
Last
direct
three
that the
lines.
interim measure, the rent controller under the West Bengal Premises Tenancy Act to decide the fair rent of the premises after hearing both the
It's
parties.
only as an interim.
this is an interim.
This was, my lord,
And
This
yes.
is an interim management arrangement.
No, but the fair rent is to be decided by the rent controller.
that is also on an,
আরে তিনের চারটা বার
Yes. Now, my lord, the next page, page 21, rent controller shall decide the fair reasonable rent in accordance with law, taking into consideration the occupancy of the tenants in the premises.
this is entirely an interim measure.
Yes.
But as against, my lord, the interim order, which directed the, my lord, the rent controller to decide, but they went up before the Supreme Court. The Supreme Court, my lord, turned down lock, stock and barrel.
Right, right.
So, my lord, the point is,
এইটা whether previous is 91.
no, my lord, my point is, my lord, before your lordship, this was arising out of a writ petition filed by my client. Single judge said you paid 10,000. That was in appeal before the division bench. The division bench said that the fixation will be as per, my lord, the West Bengal Premises Tenancy Act 1956. Therefore, my learned friend's contention that they don't come within the purview of 1956 Act, but at this stage, but he cannot take this plea because this was not argued before the Supreme Court, and the Supreme Court turned down.
Lord,
The
kindly see-
fixation is to be by the rent controller.
My lord, I do not know, my lord, we do not know what is the fate of the appeal. This is an
The
interim
fixation
management.
of fair rent.
My lord, we do not know what is the fate of the appeal.
That is also annexed.
But final order has not been annexed. Interim order has been annexed.
The specialty petition.
Thereafter, there was a settlement between the parties.
Yes, thereafter settlement. Your lordship kindly sees section 3, Roman 4.
সেটা তো ওরা কনসিডার করছে ন্যাচারাল জাস্টিস whichever way they're fixing it without giving any opportunity.
Your lordship has seen section 3, Roman 4. It's a statutory body which is not a local authority. So, we do not come under the purview of this act. Being the statutory authority, we have no other option but to seek guidance from the LA collector. And LA collector in turn sent us to the valuation board. Valuation assess the valuation, and it has been assessed as rupees 41 per square foot. And that's why fair rent has been fixed on the basis of the valuation made by the.
Only thing the petitioner ought to have been heard.
Yes.
So that's the only ground on which.
So, if your lordship so directs, we could hear them and revisit the matter. And in the meantime, your lordship kindly enhance the rate, like previously this court did in previous occasion, previous litigation. Your lordship kindly sees.
Let the authority decide.
But we would decide in the intervening period. In the intervening period, they should pay at least rupees 30 to 35,000 per month. They are occupying. This is the court of equity.
On what basis can the court
as an interim measurement? Because since 2010 we have been receiving.
20, 30.
Kindly increase the rent.
There be some basis for assessment by the court. The court doesn't have the machinery.
But previously, in the first round of litigation.
Make any comment on the previous litigation. The court might have assessed, but I don't think I can.
So, some sort of enhancement, this is the code of equity.
This order has to go, otherwise they are.
On the ground that you were not heard. The
Yes.
Tenancy Act thing is not in your favor.
Lordship.
That's all.
Kindly increase the rent to some extent.
But I'll be objecting to that.
Kindly visualize the
It has to be decided by the authority.
And I'm paying. It is not that I'm a defaulter. Agreed rent I am paying.
But 5,000 in respect of 1,000 square foot at Dalhousie area.
That was agreed by you.
In 2010.
10,000 was reduced to 5,000.
Yes.
Because I gave up half of the area.
Half portion gave up.
I gave up
They have
half.
given up.
That's the reason pro rata.
Now you have 500 square feet with you.
1,000 square.
1,000 out of 2,000. Yes, absolutely.
1,000. Kindly enhance the rent to some extent.
For the parties. The petitioner is a tenant in respect of the premises. Petitioners are tenants in respect of the premises in question.
For your lordship's assistance, we have prepared a report. Kindly go through it. Before passing the product.
The key.
Please hand over a copy to.
Yes. Kindly go through this.
Synopsis.
Yes, short. No. The second page.
Draft synopsis. তোমার মক্কেল তোমাকে ইনস্ট্রাকশন দিয়েছে
কোর্টের অ্যাসিস্ট্যান্সের জন্য আমরা বোর্ডস কন্টেনশন
আগেরটা দাও না তাহলে যেখানে আমরা দিয়েছিলাম না তো আগেরটা দাও তাহলে সুবিধা
এইটা
এই পাঠানো হয়েছিল না
out of 30 tenants 20 agreed to that amount.
So that doesn't necessarily mean that the 21st will also agree.
No, that is the fact. Admitted fact.
এগুলো দিয়ে এগুলো পাঠানো সেটা তো জজ মার্চ
Coordinate bench of this court, by an order passed on December 19th, 2000, fixed the rent of the premises at rupees 10,000 per month. Stop. The said order was carried in appeal by the petitioner and by an order passed on 9th April 2001 in MAT 132 of 2001, an honorable division bench of this court modified the order passed by the single bench and directed as an interim measure, the rent controller under the West Bengal Premises Tenancy Act, 1956, to decide the fair rent of the premises after hearing both the parties within a stipulated time frame. The court recorded that it was an interim arrangement subject to objection which was raised by the learned counsel for the West Bengal Khadi and Village Industries Board.
In spite of that,
The rent controller was directed to decide the fair/reasonable rent in accordance with law, taking into consideration the occupancy of the tenants in the premises.
আর কি বলার আছে আপনি দিতে পারেন
The respondents preferred a special leave petition against the said order before the Honorable Supreme Court, which was dismissed by an order passed on 21st January 2002, 21st January 2002 in SLP within bracket civil number 10442 of 2001. Paragraph. The petitioners complain. It is contended on behalf of the petitioners that the offer of rent made by the petitioners was accepted by the authority with a letter issued on 17th September 2010. A bill was slapped upon the petitioners on 4th December 2023, assessing the rent from 1st January 2023 to November 2023 to the tune of rupees 4,51,484.94, which is impugned in the present application. Paragraph. Learned counsel for the petitioners submits that since the Honorable Division Bench directed the rent controller to assess the fair rent in respect of the premises in question, the tenancy is governed by the West Bengal Premises Tenancy Act, 1956, and the impugned assessment could not have been made by the first land acquisition collector, Kolkata. Also, no opportunity of hearing was granted to the petitioners prior to such assessment. These are your 2 points. Paragraph. Learned counsel for the respondents points out that the Honorable Division Bench directed the rent controller to assess fair rent only as an interim measure in terms of section 3,
Roman 4.
3 small a, quarter bracket, next bracket, Roman 4, I3, small of the Premises Tenancy Act 1997, the premises in question is not governed by this act. Paragraph.
Government premises
I
eviction of
order
unauthorized occupants act.
passed on 9th April
Government
2001.
premises tenancy
The
regulation.
Honorable Division Bench directed the rent controller to assess the fair rent of the premises only as an interim measure, and the provision referred to earlier clearly depicts that the premises in question is not governed under the West Bengal Premises Tenancy Act. Stop. It is not in dispute that no opportunity of hearing was granted to the petitioners before fixation of rent by the first land acquisition collector. Stop.
But I have also
For alone, the bill raised by the land acquisition collector on 4th December 2023 is required to be set aside. Paragraph in view of the above, the petition being WPO such is allowed. Paragraph, the bill raised by the first land acquisition collector, Kolkata on 4th December 2023 is set aside. Paragraph,
since 2000,
the first land acquisition collector is not a party to the writ petition.
No, he did not communicate it directly with me.
So why don't you add him as a party? Because he has to be directed.
If
to
your lordship
consider.
directs, my lord, I will.
I'll do that. The first land acquisition collector,
Kolkata.
Kolkata, is directed to revisit the issue upon granting reasonable opportunity of hearing to all concerned, including the petitioners, and take a reasoned decision within 1 month.
Lordship,
Within 1 month from the date of communication of this order, in accordance with law. The petition for disposal of bullets, they shall have been ordered as to costs. Since
your lordship has not gone into the merits of this case. Kindly, my lord,
no order as to costs, line acting. It is made clear that this court has not gone into the merits of the case, and the concerned respondent shall be at liberty in accordance with law.
But after
since 2000, my lord, rent has not been revised, my lord. So, my lord,
Precise, sir. একদম শুরুতে একটা লাইন করুন on prayer of the petitioners, liberty is granted to implead the first land acquisition collector, Kolkata, as respondent number 4 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly.
Okay.
To the necessary.
I'll immediately do that. No, the other thing is that the first land acquisition collector will give me an opportunity to contest the fixation.
That has been said.
But maybe instead of 1 month, 2 months, because I do not.
1 month, my lord, rent has not been revised since long, 2000, my lord, and we are paying, my lord. Property tax, my lord, it has been enhanced 20 times. 20 times, my lord, property tax has been enhanced. But from the date of communication, my lord.
Right.
And since, my lord, I have not used any affidavit, my lord, all allegations are denied. Since I have
And the order appearing at page 50, that is also to be set aside, my lord. That demand for payment in terms of page 47. Page 47 is set aside, as well as not the page 50.
If my lord 47 goes, automatically 50
Yes,
goes.
that's the reason I want to have
Logical.
it. Yes. There's consequential.
Consequential.
And the demand issued on 29th January, it should be 2024.
And they should, my lord, pay, my lord,
29 January 2024.
current rent pay করতে বলবে? And they should pay, my lord, current rent month.
Oh, of course.
In
There's no allegation that I'm not paying.
They are
Certainly, I'm up to date.
Thank you.
Yes, fine.